In the Senate of the United States, a resolution to establish a select committee of the Senate to conduct an investigation and study of the extent, if any, to which illegal, improper, or unethical activities were engaged in by any persons acting individually or in combination with others in the presidential election of 1972, or any campaign, canvass, or other activity related to it.
From Washington, NPAC brings you gavel-to-gavel videotape coverage of today's hearings by the Senate Select Committee on Presidential Campaign Activities. Here is NPAC senior correspondent Robert McNeil.
Good evening. More intense drama today in the fourth day of the Senate Committee's public hearings on Watergate. Once again, NPAC brings you unedited, complete coverage in prime time. So far, we've been hearing testimony which tended to amplify or corroborate what the public already knew. Today, there was the first real conflict in testimony, conflict which could result in possible charges of perjury. The most dramatic witness was one not originally part of the committee's game plan to let the Watergates unfold methodically and chronologically. But today the committee, by its own ground rules, had to let McCord's estranged defense attorney, Gerald Alch, come to defend himself against McCord's charges of improper professional conduct. Alch vehemently attempted to justify himself and said that parts of McCord's testimony were either not true or were twisted. Alch also opened up a totally new avenue in this increasingly confused affair. He made charges against McCord's new attorney, Bernard Fensterwald, which suggested a vendetta to incriminate President Nixon. But the first witness today gave evidence that came close to suggesting the President himself knew about offers of executive clemency to McCord, something President Nixon denied yesterday. The witness was John Caulfield, the former White House aide, who transmitted the offers to McCord from Presidential Counsel John Dean.
I had this conversation with John Dean, who's the counsel to the President. I've been there 3 years. I know what the relations are and how they exist. I make certain judgments based upon those relationships. In my mind, I felt that the President probably did know about it. Now I'm going out the door to become more specific. And it crossed my mind that this conceivably was for the President. I believed it. I had to think about that. And based upon all of that background, I believed I was doing something for the President of the United States. And I did it, sir.
Meanwhile, back at the rest of the world outside the hearing room, Watergate and the crisis it has spawned continued to have an impact on developments elsewhere. In another Senate committee and finally on the floor of the Senate, Elliot Richardson was confirmed as Attorney General of the United States. The full Senate vote was 82-3 following the favorable report of the Senate Judiciary Committee. The confirmation of Richardson clears the way for Archibald Cox, the Harvard Law professor and former Solicitor General of the United States, to start his labors as Watergate Special Prosecutor. There is nothing new today, by the way, on whether or not the current prosecuting team, headed by Assistant United States Attorney Earl Silbert, will or will not continue to run things before the federal Watergate grand jury here in Washington. In another key congressional vote, the House failed by a 40-vote margin to gain the two-thirds vote necessary to override the President's veto of a bill that would have subjected the President's appointment ahead of the Office of Management and Budget to congressional approval. As you'll recall, the Senate had previously voted to override the veto. In short, the President won the round, a display of strength in adversity. And speaking of the President, reaction to his statement of yesterday continued. Senator Howard Baker, Vice Chairman of the Senate Watergate Committee, was asked during a break today if the President's new revelations would have any effect on the conduct of the hearings.
I think the statement was more exact and specific than his statements heretofore. I think it responded to a number of things that have been brought out in testimony before the committee. And I hope what I say next isn't either arrogant or presumptuous, but just as I've imposed a discipline on myself to refrain from commenting on any witness's testimony and its meaning or my conclusions about it, I think I ought to refrain from stating any conclusions about the effect or impact of the president.
So you're putting this in the hopper just like the testimony of all the other witnesses?
It would disserve the committee if I tried to say this does or does not prove a particular point.
Thank you very much, Senator.
The legal questions raised by today's testimony will be months, possibly years, coming to a final conclusion. But Attorney Gerald Alch, recounting in detail his conversations and relationships with his former client, James McCord, presented a lot of unique and unusual aspects, other than the obvious headline bit of glaring discrepancies in what actually happened. We asked Bill Greenhall, a Georgetown University Law Center professor who viewed the entire day's proceedings with us, about this.
Yeah, I think you'll observe a singularly unique experience of what happens in a particularly famous criminal trial when a client waives his attorney-client privilege and all the ramifications contained therein. I think you're going to see details as to pretrial, trial, and appellate strategy, procedure, and heretofore privileged communications between the lawyer and his client.
And these are things that are normally never spoken of publicly.
It's certainly not in the context by which you will see tonight.
We'll be talking to Bill Greenhall again about other legal aspects of what happened today at the end of the program tonight. Robin?
Now, as you settle back for the latest chapter in the Watergate saga, here is an hour-by-hour viewing guide. The hearings open with testimony by former New York policeman John Caulfield, who says his role in events following the break-in was merely as a messenger. Under questioning, he admits he knew trying to silence a witness is illegal, but says he did it out of loyalty to President Nixon. Caulfield continues in the second hour, saying he originally resisted a request from John Dean to call McCord because he saw it involved dangerous involvement in the case. But he ultimately arranged the contact because he felt the president approved. Caulfield admits he had no first-hand knowledge that the president knew of the arrangements. Caulfield is followed by Anthony Ulazowitz, the man who made 2 anonymous phone calls to McCord. Ulazowitz said he was paid by Herbert Kalmbach, the president's own lawyer. Ulazowitz has high praise for James McCord as a wireman or electronics expert, but says he was surprised McCord was caught, virtually in the act, at the Watergate. During the third hour, we hear testimony from Gerald Alch, McCord's former lawyer. Alch adds some new wrinkles and some contradictions to McCord's story of how his defense was planned. He says McCord rejected his attempts at plea bargaining, but says feelers in that direction came from federal prosecutors, not the White House. Alch explains McCord's projected defense of duress. In the last part of his statement, Alch introduces a surprise, saying that McCord's new attorney, Bernard Fensterwald, suggested the two cooperate to, in his words, go after the president as a means of freeing McCord. But now let's start at the hearings, as Senator Sam Ervin opened them in the Senate caucus room this morning. The witness is John Caulfield, and his attorney beside him, John Sears, a former aide in the Nixon campaign of 1968 and again in 1972, a lawyer in Nixon's old law firm in New York. Senator Ervin.
The committee will come to order, and I would like to reiterate what I stated yesterday, that Mr. Caulfield is to return later, and that I hope that questions at this appearance will be restricted to matters dealing with the communications between him and Mr. McCord in respect to the question of clemency.
May I inquire what the plan of the committee is on the witness following Mr. Caulfield?
Yes, the witness following Mr. Caulfield will be Tony Ulazowitz, who will be the individual who has been identified as the person who made the telephone call to Mr. McCord, and that he will be called specifically to testify as to that role. He, too, will be available, Senator Gurney, to come back and to testify to other matters which he has to testify before this committee.
Mr. Chairman, I understand that last evening the counsel interviewed the attorney, the former attorney for Mr. McCord, and that his statements were in startling conflict and contrast to what Mr. McCord told us here the other day. I would think it would be extremely important that we get this witness on just as soon as possible, and I, as one committee member, would like to see him on this afternoon. Because I think his testimony is such a total contrast to what Mr. McCord said. I think he should be called just as soon as we can get him, and hopefully after the recess, before we call Tony.
We can do that, Mr. Chairman. That would not in any way. In fact, it is true that Mr. Alch did come in and did request to be called. We thought we would call him immediately after Tony Ehrlichman, but there's no reason why he cannot be called immediately after Mr. Caulfield.
I wish he might.
Thus, a sticky problem for the committee, when to bring on rebuttal witnesses. Senator Gurney, aware that former McCord attorney Gerald Alch had been maligned by McCord, wanted Alch on quickly to tell his side of the story, a story that was considerably different than McCord's. This whole business of discrepancies in testimony and the procedural problem of if and when to bring the witnesses on is a dilemma that the committee had to decide today and undoubtedly will face again throughout the hearings. Here are the three main figures in the conduct of the hearings discussing this very matter. Senator Ervin in the middle with Senator Howard Baker and Sam Dash, the counsel.
Let me make a suggestion, if I may. I think Senator Gurney's point is well taken. However, in the interest of continuity and in keeping with the preparation that the committee's made, let me make an alternative suggestion, if I may. Let's finish with Mr. Caulfield today, Mr. Chairman, I would suggest, which I think we can do in a reasonably short period of time. Since Mr. Caulfield, I understand, is agreeable to returning to explore other matters not directly related to the subject matter of his testimony thus far, that we go forward then with the next witness, who is
Tony Ehrlichman, and I think he only should take about 10 to 15 minutes.
And if we finish that, then move on to Mr. Alch. That would preserve some semblance of the continuity and still, I believe, accomplish Senator Gurney's request. That would almost assure that Mr. Alch would be on the stand today.
Well, that, of course, is what I'm trying to do to assure that he does get on the stand. We have taken sometimes a good deal of time in the questioning. In fact, I've used my own fair share, but I do think it's awfully important that we get Mr. Alch on today, because his testimony is going to be in such sharp contrast and contradiction to what we learned from Mr. McCord earlier. And I think we ought to get it to clear up some of these things that are hanging around the room here.
Mr. Chairman, it's my understanding then that only so that we might present a logical picture, we will restrict our questions to the matters that Mr. Caulfield raised yesterday in his testimony, but certainly that there are no restrictions and no bars as to future testimony, and that he will be recalled for any questions that we want to ask. Is that correct?
Yeah, that is correct.
Thank you very much, Mr. Chairman.
Mr. Caulfield, because your statement was a lengthy one and there was a recess over the evening, let me seek to briefly summarize the essential highlights of your statement that you gave to the committee, and please correct me if anything I say is not consistent with your understanding of your statement. In December of 1972, you received an unsigned note which you understood came from Mr. McCord, which complained of a White House effort to blame CIA for the Watergate and threatened that, quote, all the trees in the forest will fall, unquote, if this effort continued. In early January 1972, while you were in California, you received a telephone call from John Dean from Washington asking you to deliver the following message to Mr. Dean. 1, a year is a long time. 2, your wife and family will be taken care of. 3, you will be rehabilitated with employment when this is over. You did not want to deliver the message, but you thought that it could be delivered through Mr. Tony Ehrlichman, and Mr. Dean agreed to do it that way.
Mr. Dash, can I interrupt a second? The correct pronunciation is Ehrlichman.
Ehrlichman.
Yes, sir.
All right. You did call Mr. Ulasewicz, and you asked him to deliver this message. And although he himself at first was reluctant, he did agree to deliver the message, and he did call Mr. McCord and reported back to you that Mr. McCord appeared satisfied, and you reported this to Mr. Dean. The following day, you received another call from Mr. Dean informing you that McCord wanted to see you when you returned to Washington. You had Ulasewicz arrange the meeting, which was set for Friday, January 12th at the second overlook on the George Washington Parkway. In substance, you emphasized that you were only a messenger, that the offer you were conveying of executive clemency was from the highest levels of the White House, and that it was a sincere offer. McCord's response in substance was that he wanted his complete freedom, and even suggested a plan which involved proving that the government had wiretapped his telephone calls, that he had made 2 calls to foreign embassies whose phones he believed were wiretapped. You do not recall saying anything about the President to Mr. McCord, but you did transmit an offer of executive clemency to Mr. McCord, which you told him came from the highest levels of the White House. You reported this meeting to Mr. Dean on the telephone. The following day, you met with Mr. Dean, and he told you to go back to Mr. McCord and impress upon him as fully as you could that the offer of executive clemency was a sincere offer. And when you asked if you should mention any names, such as the President, he said no, but told you that you should say that the offer came, quote, from way up top. Mr. Dean also expressed his concern over this matter as a grave situation that could threaten the President and could become a national scandal, that none of the other defendants in the Watergate case were any problem, and Mr. McCord was not cooperating with his attorney. You again met with Mr. McCord at the second overlook on the George Washington Parkway on January 14 for a short while and conveyed the message of concern over a national scandal which could threaten the President, and that McCord was the only one of the defendants not cooperating. Again, McCord expressed his interest to you in securing his freedom and wanted you to do something about the wiretaps he had mentioned to you earlier. You telephoned Mr. Dean that same day and told him that Mr. McCord was not interested in executive clemency, and that Mr. McCord believed that the White House could help him get the charges dismissed by supplying proof of the wiretaps for him. You had a final meeting with Mr. McCord on a date you cannot recall, but about the third week in January, where you picked him up in your automobile on the second overlook on the George Washington Parkway and drove for about an hour or two. At this time, you told him that the White House could not do anything for him about the wiretap problem, and there was a lengthy conversation which for the most part involved other subjects than Watergate. You concluded during that conversation that Mr. McCord definitely was going to make a statement on the Watergate burglary, and it would probably involve allegations against people in the White House and other high administration officials. You gave him what you indicated to the committee as friendly advice to the effect, quote, Jim, I have worked with these people and I know them to be as tough-minded as you and I. When you make your statement, don't underestimate them. If I were in your shoes, I would probably be doing the same thing. But you also had received from Mr. McCord some reference or a request to do something about bail, and you were not able to accomplish anything on the bail issue in further contacts with him. That at no time did you talk with the President about this matter or mention the President to Mr. McCord concerning the offer of executive clemency, but that you carried this message to Mr. McCord because you felt it was for the good of the President. Is that basically a fair summary of the gist of the contact with Mr. McCord and Mr. Dean that is contained in your statement?
Yes, sir.
Now, although you state that you made no mention of the President to Mr. McCord during your meetings, you do know, do you not, that the President is the only person in this country who can grant executive clemency in a federal criminal matter?
Yes, sir, I do.
Did you understand, when you were speaking with Mr. Dean, that Mr. Dean wanted you to transmit the message to Mr. McCord that the offer of executive clemency was made with proper authority?
Yes, sir.
Was it your intention during your meetings with Mr. McCord to leave him with the clear understanding that the persons with the authority to make such a representation as executive clemency were in fact extending this offer to him?
Just repeat it for me, Mr. Dash.
Yes. Was it your intention during your meetings with Mr. McCord to leave him with the clear understanding that persons with authority to make such a representation as to executive clemency were in fact extending this offer to him?
Yes, sir. But of course, I have no, and did not at that time, have any direct knowledge that the President had made such an offer, endorsed such an offer, or in any way was involved in that offer.
No, I understand that.
Right.
Now, looking back, Mr. Caulfield, what do you see your role to have been in this relationship, and what do you think about it?
Well, as I've indicated in my statement, Mr. Dash, I viewed myself as a messenger between Mr. Dean and Mr. McCord, exchanging information back and forth on the ongoing negotiations, which obviously had been taking place prior to the time that I had received a telephone call in California.
And was it your understanding at that time, especially with the discussions you had with Mr. Dean, that there was serious concern at the White House that at least Mr. Dean was conveying to you involving a possible scandal, that there was a real effort to get Mr. McCord to accept this offer because of the concern or trouble or problem he might be able to raise in the Watergate case?
That was my clear impression, Mr. Dash. Yes, sir.
And you were being asked to do this because of your friendly relationship with Mr. McCord?
That's correct.
I have no further questions, Mr. Chairman.
Thank you. Mr. Caulfield, as I understand that you've been a personal friend of Mr. McCord, is that correct?
That's correct, sir.
Would you still say that that relationship exists as far as you are concerned?
Yes, sir. I still consider Jim McCord to be my friend.
As you were talking to him about the possibility of executive clemency and he was responding to you, what would you say, according to what he told you, his primary interest was?
Very frankly, sir, as I reflect back upon the conversation, it's very clear in my mind that Jim McCord was concerned about his freedom and was taking the steps that he believed necessary to gain that freedom totally. He was uninterested in any deals of years a long time or other statements like that. He, in that first conversation at the car, made it crystal clear to me that he was different from the others, that I could check it if I wanted to, that he wanted his freedom, period.
In other words, he was not necessarily disinterested in any deals, but he was not interested in any deals that would not produce his freedom. Is that a correct statement?
That's correct. That's correct.
As you state here in your statement, he continually said that all he was interested in was his freedom. And he was not pleased that some of the others who had been involved were not suffering as he was suffering. Is that correct?
That's correct.
Right. You referred also in your statement to his plan, the plan which he had, which he thought would produce his freedom. And I believe you referred to his 2 telephone calls in September and October of 1972 to the 2 embassies.
Yes, sir.
According to what he told you, was it your impression that he believed that these 2 calls were made in order to ultimately produce his freedom, put the government in an embarrassing position, and therefore produce his freedom.
Yes, sir.
All right, now let me ask you about your relationship with Mr. Ehrlichman for just a few moments. How long did you work for Mr. Ehrlichman when he was counsel to the President?
From the day that I arrived at the White House on April 8, 1969, formally through July 70 when Mr. Ehrlichman moved over to the Domestic Council, and then on an informal basis from that time till the time I departed the White House.
And after Mr. Ehrlichman left the office of counsel to the President, Mr. Dean was his successor, is that correct?
Yes, sir.
You remained there in the office under Mr. Dean, is that correct? Did you have any contact or any continuing relationship with Mr. Ehrlichman after Mr. Ehrlichman left to go to the Office of Domestic Affairs?
Well, only on rare peripheral matters relative to the investigations that I indicated in my statement.
And while you were working for Mr. Ehrlichman directly, as I understand that you had possibly more than one function, but one of those was to carry out certain investigations.
Yes, I had many other functions, sir, but that was one small part of my duties at the White House, sir.
And you continued to do some of these matters for him or pursuant to his direction after he left
on
that office?
Very rare occasions, sir.
Would you, on some occasions, act as an intermediary between Mr. Ehrlichman and Tony Ulasewicz for,
yes,
for jobs that Mr. Ulasewicz would do?
Yes, sir.
Would you say that that would be a frequent occasion?
That would be infrequent after July of 1970.
But occasionally. Now, Mr.
oh, yes. Yes, sir.
Mr. Caulfield, in your statement here, you state that you were guessing that Mr. Dean probably was referring to Mr. Ehrlichman when he referred to high White House sources.
Yes,
that was your guess at
yes,
the time. Now, you also go ahead to state that you say, I know that he was in conversation with someone about my contacts with Mr. McCord, since when I was in his office on January 13, he received a telephone call, and I heard him say, I'm receiving a report on that right now. Are you referring to Mr. Ehrlichman?
No, what I'm saying was the call came in, there were no names mentioned. Mr. Dean said I'm receiving, there was apparently the party calling made some comments. Mr. Dean said I'm getting a report on that right now.
Oh, I see. This conversation that you overheard was with Mr. Dean and someone else.
I'm in Mr. Dean's presence, Mr. Thompson.
I see. And you assume that perhaps that conversation was with Mr. Ehrlichman? Or possibly with Mr. Ehrlichman?
Possibly with Mr. Ehrlichman, but I have no way of knowing, sir.
You feel like, very definitely in your mind, that he was talking with someone else there about it. Is that correct?
Well, I want to be careful there, sir, because I just don't know where the call come from. If it was coming from outside, it could have been someone else. If it was coming from within the White House, then it was someone in the White House. So, by that I mean, sir, there was an inter-office telephone system. Now, I do not know and have no way of knowing whether or not that was an inter-office call or whether or not it was a call coming from outside.
I see.
So that's why I mentioned it that way.
What would you say was the relationship between Mr. Dean and Mr. Ehrlichman during this period of time? Did Mr. Dean, in many matters, in effect, report to Mr. Ehrlichman or
yes, sir.
Answer to Mr. Ehrlichman?
Yes, sir, in many matters having to do with Mr. Dean's work and Mr. Ehrlichman's work as well.
Did you ever talk to Mr. Ehrlichman about this matter, this business of possible executive clemency from Mr. McCord?
No, sir.
Or anyone?
No, sir.
You never did?
No, sir.
Did you ever talk to anyone there at the White House besides Mr. Dean?
Absolutely no one but Mr. John Dean.
I have no further questions, Mr. Chairman.
If no objection, part of the, excuse me. If there's no objection, I'd like to exchange places for questioning witnesses with Senator Montoya and let him take my place, and then I'll take his, what he would ordinarily take.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. Mr. Caulfield, I think we better get your background and your employment duties at the White House in better perspective. What exactly were you doing when you went to work at the White House in April of 1969?
My prime duties at the White House was to act as a liaison, primarily with the United States Secret Service and other federal law enforcement agencies. As I indicated, I worked under Mr. Ehrlichman. Mr. Krogh was under Mr. Ehrlichman as well. And from time to time, I would be assigned major projects that come up in the law enforcement area. For example, shortly after coming to the White House, I was assigned to the then emerging drug abuse task force that subsequently emerged as Operation Intercept.
Well, were you working directly under Mr. Ehrlichman, or were you working under Mr. Dean?
No, Mr. Dean, sir, was not at the White House at that time. This is, you asked, I think the question was, what were my duties when I went into the White House?
Yes.
And when I went into the White House, Mr. John Dean was not yet there. He was at the Justice Department.
Well, as I understand, you went to work at the White House on April 1969, and you worked there until March 1972. Is that correct?
Yes, sir.
All right. Were you on the payroll of the White House, or were you being paid by someone else?
No, I was on the White House payroll, sir.
Did you ever get paid from the President's attorney?
No, sir.
And were you assigned to the White House payroll, or were you on the Treasury payroll?
I don't quite understand.
Were you working or being paid from the payroll attributable to the Department of the Treasury or to the White House?
At the White House payroll, sir.
All right.
Yes, sir.
Now, did you come in contact quite frequently with Mr. Ehrlichman?
In the course of my duties, yes, sir. Not on a daily basis, certainly, but I would be working with his staff people, Mr. Eagle Krogh, when I first went in there. And as I've indicated, I would be assigned major projects. I was the White House representative for the Marijuana and Dangerous Drug Task Force that began in the spring of 1969.
All right, now, in the course of your employment at the White House, what relationship did you have with Mr. Dean when he came on board?
Well, Mr. John Ehrlichman, when I was working for him, coming aboard the White House, was counsel to the President. When Mr. Ehrlichman became the presidential assistant and headed up the Domestic Affairs Council, Mr. John Dean came in and became the counsel to the President, and I remained in the office of the counsel to the President under Mr. Dean, my direct supervisor.
Did he assign many things to you?
Yes, sir.
Did Mr. Ehrlichman continue to assign things to you to do?
As I've indicated, Senator, only on rare occasions after Mr. Ehrlichman became assistant to the President for Domestic Affairs.
Did Mr. Haldeman assign things to you?
On only one or two occasions that I can recall, Senator, very rarely, in fact, almost never.
All right. Now, you mentioned that you had interviewed Mr. McCord for his employment at the executive offices and recommended him to go to work for the committee to re-elect the president. That is correct, isn't it?
Well, that's essentially correct, Senator. The recommendation was for employment at the Republican National Committee initially, and flowing from that, Mr. McCord was hired by the committee to re-elect.
How many interviews did you say you had with Mr. McCord?
I recall two. I recall a luncheon when it was already established that he was on board.
Who did you clear with at the White House before you recommended Mr. McCord for that employment?
I didn't clear anybody, sir.
Who did you call at the Republican National Committee?
I called Mr. Barry Mountain, who was the then deputy chairman for administration.
Had he asked you to recommend someone?
Yes, sir.
And was there a job classification for the individual that he wanted?
No, as I recall, the way Mr. Mountain explained it to me, they wanted someone to come up and do a security survey, and possibly following the survey, the party who did the survey would be hired as a supervisor of security at the Republican National Committee.
Was there any discussion with respect to that classification, that the man who would be chosen and the man that you might interview should be qualified in espionage activities for the party?
Absolutely not, sir.
Were you aware that that was one of the competencies that this man should have anyway?
No, sir. In reviewing Mr. McCord's qualifications, they appeared to me, from a career experience in security work, to be absolutely outstanding, and his credentials appeared to be impeccable.
Now, what did you conceive with respect to the game plan that was going on at the time?
I beg your pardon,
Mr. McCord mentioned that you had told him that he was ruining the game plan. What did you conceive that to be?
Well, sir, I don't recall Mr. McCord saying game plan, but it was obvious to me that there were negotiations going on with respect to executive clemency for Mr. McCord.
Well, let me read to you from Mr. McCord's statement on page 9. And I read as follows. I refused to discuss it. He stated that I was fouling up the game plan. I made a few comments about the game plan. That was Mr. McCord's statement on page 9. Do you recall that conversation?
I don't recall those words, Senator.
Well, what words akin to that were uttered by you in the presence of Mr. McCord?
Senator, I'm a little confused on, they're asking me that, I have no recollection of Mr. McCord, of me saying to Mr. McCord, I was fouling up the game plan. My statement doesn't indicate that.
Well, let me read you an extended text of that statement. On page 9, about 10 o'clock a.m. on Thursday, January 25th, 1973, in a meeting lasting until about 12:30 a.m., we drove in his car toward Warrenton, Virginia, and returned. And a conversation ensued which repeated the offers of executive clemency and financial support while in prison, and rehabilitation later. I refused to discuss it. He stated that I was fouling up the game plan. I made a few comments about the game plan.
Yes, sir.
Do you recall that?
No, sir, I do not. As I indicated in my statement, this trip here was one of friendly conversation between two friends. I have no recollection of offering him executive clemency on that occasion. I have no recollection about stating that I was fouling up the game plan.
Now, did Mr. Dean tell you why he was calling you to get in touch with McCord?
When was that?
When he called you at San Clemente.
He indicated to me that he had a very important message that he wanted to be delivered to James McCord.
Well, I understand that, but did he tell you why he had chosen you for that mission?
No, sir, he didn't.
Did you ask him?
No, sir. He knew, of course, that I had known Jim McCord.
How did he know? Had you discussed Jim McCord?
Well, I had been over at the committee. Eventually, after he was hired, I'm sure that I mentioned to Mr. Dean that this fellow McCord is hired. He appears to be outstanding. He was well aware that I knew James McCord. There was no question in anybody's mind.
Did you get in touch after Watergate with Mr. Dean to indicate to him about your friendship with Jim McCord?
Would you repeat that, Mr. Senator, please?
Did you get in touch with Mr. Dean and communicate to him your friendship with Jim McCord?
When, sir?
After the Watergate break-in.
Oh, we had conversations. I expressed shock on many occasions that James McCord was arrested at the Watergate.
No, but the point I'm trying to make, Mr. Caulfield, that you had 2 or 3 interviews with Mr. McCord. They were short in duration.
Yes, sir.
Preliminary to his being hired.
Yes, sir.
There were other people at the Republican National Committee and at the Committee to Re-elect the President,
yes, sir,
who knew Mr. McCord better than you did, presumably because he worked with him for a longer time. And I am wondering why Mr. Dean selected you to carry on this mission of offering executive clemency to Mr. McCord, when there were other people within the organization of the National Committee and the CRP who had developed a better and more intimate acquaintance with Mr. McCord.
Well, of course, I'm sure that Mr. Dean trusted me, and in reading some of the things that might have gone on before, there was apparently a need for someone from the White House to bring a message to him. And certainly Mr. Dean knew that I knew Jim McCord. And then I'd like to reiterate that I received a letter in December, which I brought to Mr. Dean's attention, wherein it was alleged that the White House was involved in attempting to place the blame on CIA. So all of these things Mr. Dean knew. Mr. McCord sent me the letter. Mr. Dean knew that.
Did you ever inquire of Mr. Dean when he was telling you just what to say to Mr. McCord? Did you ever inquire from him as to the high sources and who they were?
Well, sir, in the first telephone call, this was all just him asking me to go and deliver this message to Jim McCord. Subsequently, as I've indicated in my statement, we did have a conversation after the first meeting.
Now, you mentioned that Mr. Dean had instructed you to say that it comes from way up at the top.
Yes, sir.
Now, what did you conceive that to be at the time?
Well, sir, in my mind, I believed that he was talking about the president.
All right.
Although, again,
how would you have interpreted that without any further explanation? The same way?
I don't understand, Senator.
You mentioned that it was your impression that it must have come from the President. Now, did you, when you reached that impression, question Mr. Dean any further about it?
No, sir.
My time has run out, so I will not pursue that any further. Thank you, Mr. Chairman.
Senator Garney. Wait a minute.
Mr. Chairman, I'd like to follow your example. I would offer to yield to Senator Weicker at this point. I understand from the previous conversation that he may not wish to yield to Senator Gurney.
Mr. Chairman, I just have two very brief questions, and then we yield. Mr. Caulfield, if you could turn to page 19 of your testimony. You state there, I have been asked at the U.S. Attorney's Office and by Senate investigators, and have tried as best as I can to recall what impressions I had at this particular point in time. As best as these impressions can be stated, I believed that I was going back to see Mr. McCord to again extend an offer of executive clemency, and that by doing so I was doing a great service for the President of the United States in a very sensitive matter. And my first question to you very simply is this, to use your own words. I'd like you to comment or explain to me why it is that you thought that you were doing a great service for the President of the United States.
Well, sir, if you go back a little bit, it was a great honor for me to serve as a member of the President's staff. I had come from a rather humble background, police officer. I did receive this great opportunity to serve on the President's staff. I felt very strongly about the President, extremely strongly about the President. I was very loyal to his people that I work for. I place a high value upon loyalty. Now, out of the blue, I'm injected into this scandal. I'm being asked by one of my former superiors to deliver a message that I know to be executive clemency. I tried to avoid it, as my statement indicates. I imposed upon my friend to do it, hoping that all parties would be satisfied. I was not successful. I was brought back in again to it, now being asked to see Mr. McCord directly. I did go to see him. Now I'm becoming further implicated into this matter. I have this conversation with John Dean, who's the counsel to the President. I've been there 3 years. I know what the relations are and how they exist. I make certain judgments based upon those relationships. In my mind, I felt that the President probably did know about it. Now I'm going out the door to become more specific. And it crossed my mind that this conceivably was for the President. I believed it. I had to think about that. And based upon all of that background, I believed I was doing something for the President of the United States. And I did it, sir.
Mr. Caulfield, you've lived a life dedicated to the law. In the very beginning of your statement, you cite a career, a very fine career, one that was recognized time and time again. Let me ask you Let me ask you this question. Is one of the conflicts I read, let me be more specific. I read on page 24 of your testimony where you're talking to McCord and where you give him a friendly piece of advice. And you say, Jim, I've worked with these people and I know them to be as tough-minded as you and I. And when you make your statement, don't underestimate them. If I were in your shoes, I'd probably be doing the same thing. And I read that, and you tell me if I'm wrong, as a man who's in conflict with himself. On the one hand, delivering a message to a friend. On the other hand, a man whose whole career has been dedicated to honesty, of seeing the truth come out. Would that be a fair description of the conflict that was occurring within yourself at that time?
There's a definite conflict, Senator. You're absolutely right. I know when wrongdoing is occurring. I've indicated here that I knew that the offer of executive clemency in this manner was wrong. Yes, sir, I knew that. But what I'm saying to you, sir, that my loyalties, and especially to the President of the United States, overrided those considerations.
So actually there was a conflict between your loyalties, and it's interesting that you used the very word that I had in the question here written before you made your statement. Did you feel then at this moment in time a conflict between your loyalties to the President and a life dedicated to law and the pursuit of truth?
Yes, sir, and also, that's correct, and also that I was hopefully being able to help a friend.
And then lastly, Mr. Caulfield, where on page 25 you state that I realized at the time of my first conversation in January that I was involved in questionable activity, but I felt that it was important for me to carry this message, again, for the good of the President. Was there a conflict in your mind between doing an act for the good of the President and an act that would be for the good of the country?
That's a tough question, Senator. All I can say is that I did what I did for the reasons that I've stated.
I have no further questions, Mr. Chairman.
Gentlemen, at this time I yield to the distinguished senator from Hawaii, Mr. Inouye.
Thank you very much. Mr. Caulfield, am I to conclude from your responses to Senator Weicker that you are aware that you were involved in a criminal act of obstructing criminal investigations?
Yes, sir.
On your first call to Mr. McCord soon after the Watergate break-in, I noticed from your testimony that you contacted Mr. Gulesevich,
yes, sir,
a man on Mr. Kalmbach's payroll doing espionage work, to go through some very secretive process to get in touch with you. Why all this secrecy when, as you stated, it was just to convey your sympathies to Mr. McCord? Why did you go through all this secret movement? Were you afraid that the phones were tapped?
Are you speaking about my call to asking Mr. Ulasewicz to call James McCord, sir?
Yeah, why did you go through all that secret step to get in touch with Mr. McCord? According to your statement, all you wanted to say was, I feel sorry for you, can I do anything for you?
Yes,
Isn't
sir.
that right?
Yes, sir. To have spent a career in security work as I have, and as Mr. McCord had, and to watch the daily accounts of the Watergate developments from June 17th on, it certainly occurred to me, sir, that any conversations taking place over Mr. McCord's home telephone conceivably could have been the subject of some type of wiretapping by either governmental parties or other people who were concerned about Mr. McCord. Plus the facts are, well, I should go back a little bit. That impression, Mr. McCord, as I understand this, indicated he had the same concerns, indicated to me that a circuitous route, if I wanted to speak to him, would be the appropriate way to do it.
I'd like to call your attention to page 16 of your prepared remarks, in which you describe Mr. McCord's plan. This plan called for Mr. McCord's calling 2 foreign embassies and telling the official in such embassy that he was a defendant in the Watergate case and requesting a visa. From this, did you gather that Mr. McCord was trying to blackmail the United States government?
No,
or
sir.
were you aware that if he carried out his plan, it would place in jeopardy the national security of the United States of America?
That's a two-part question. Now, did I think that this was a blackmail?
Yes.
No, sir, I didn't think that this was a blackmail. I viewed this as an attempt on the part of a man who was distraught, who wanted his freedom, and had come across a means of obtaining that freedom. I did not consider it to be blackmail, sir. I considered, based upon my conversation with Mr. McCord, that he was distraught.
Didn't you think that there was a risk of compromising the security apparatus of the United States? As he pointed out, he would have to dismiss, the government would have to dismiss the case or admit that there were taps on these 2 embassies.
Yeah, well, sir, again, I'm passing these messages back and forth, and I passed this one back to Mr. Dean. Certainly, a matter of this type would, in my judgment, work its way up to any questions of policy and national security.
Did you think that this was a reasonable plan?
I thought it was an interesting one, sir.
You didn't think it was illegal or dangerous?
Sir, again, it's possible that these thoughts crossed my mind, but I have no recollection of it. And again, I'm being put in a position of being a messenger, and I was focusing on that. I wasn't giving consideration to all of the nuances that, serious nuances, that would
Now, as you sit here as a witness, do you consider that that plan was dangerous or illegal?
I can't judge that, Senator. It's certainly a serious matter.
So you think it's proper to set up the government in a trial like this?
Well, I don't think it's proper to set up the government, sir.
On page 24, there's one sentence that puzzles me. It says, when you make your statement, don't underestimate them. What did you mean by that?
Well, as I indicated in the statement, this was a extremely friendly conversation, Senator. I don't know if this has come through with my statement, but we're talking now for an hour and a half about families, my boys, his children, his wife, my job. It gives me the name of a fellow that he knew that might be able to help me in liaison with the post office, as I recall. This is all a very cordial conversation under very difficult conditions amongst friends. Now, as I indicated, I was convinced in my mind that he was going to go ahead at some point in time and make a statement. And looking at the broad picture, I could envision an ordeal for him, a significant ordeal, and he'd be effectively on the other side of the people that I was talking to. Now, as a friend, I don't know if he fully appreciated that, but that was the intent of my remarks, to let him know.
You're giving him friendly advice.
That's right, sir.
Not to underestimate them. What did you mean by...
Well, not to underestimate the tough-mindedness of all the players in this thing.
What did you think that the other side would do to Mr. McCord?
Oh, I had no idea. And it's apparent that Mr. McCord apparently has misinterpreted that, looking at his statement, but that wasn't the intention. I would say that to any friend that was about to make a major decision that would be tough, and I did.
Thank you very much, Mr. Chairman.
And so we have still another picture of a law enforcement officer torn between legality and loyalty. And as John Caulfield said, his loyalty to the president won out. He urged James McCord to keep silent. And he said he did it with a feeling that a message of clemency had the president's own approval. However, he repeated he'd had no contact with the president himself on this matter, dealing only with White House counsel John Dean. Caulfield, a Treasury Department official on leave, will answer some more questions in a moment. As we pause in our gavel-to-gavel coverage, we'd like to thank you very much, all of you who've taken the trouble to write us, expressing your approval for this kind of uninterrupted gavel-to-gavel coverage. So far to date, we've received more than 20,000 letters, and we're very grateful. If any more of you cared to write to us, do so easily to NPACT, Box 300, Washington, D.C. NPACT's coverage of the hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
And as the hearings resume, Republican Senator Gurney is questioning John Caulfield about his contact with the White House about messages to McCord.
Mr. Caulfield, your testimony certainly has been very full and very clear. I just want to press home one or 2 points. Referring to the previous testimony by Mr. McCord, page 320 of the record, he had this to say about his conversations and meeting with you. Caulfield stated that he was carrying the message of executive clemency to me from the very highest levels of the White House. He stated that the President of the United States was in Key Biscayne, Florida that weekend, referring to the weekend following January the 8th, the following meeting that we were in then, and that the President had been told of the results of the meeting. Did you ever learn that the President had learned of the results of any of your meetings with Mr. McCord?
Absolutely not, sir.
He also stated this further on in the testimony on the next page. Mr. McCord, he, meaning you, further stated, quote, "I may have a message to you at our next meeting from the President himself," close quote. Did you ever tell him that?
No, sir.
Did you ever have any communication with the President of the United States with regard to this so-called executive clemency offer to Mr. McCord?
None whatsoever, sir.
Did you ever hear Mr. Dean, in any of your conversations with Mr. Dean, ever refer to the fact that he had informed the President of any of these meetings?
No, sir.
Did Mr. Dean ever say to you, "The President has instructed me to make this offer of executive clemency to McCord through you," or through anybody else as far as that's concerned?
Absolutely not, sir.
Did you ever apply any pressure to Mr. McCord in any of these meetings for him to do anything in regard to this upcoming trial?
No, sir.
Did you ever urge him or advise him to plead guilty?
Never.
This point has been covered, but it is important because of Mr. McCord's testimony. My understanding is that your understanding about these calls to the embassy and the wiretaps on the embassy, that this was his theory of defense, a way that he could get out of it by having the case dismissed if these wiretaps had occurred. Is that correct?
That's correct.
Did Mr. McCord ever discuss with you whatever plans he might have if he were found guilty at the trial?
No, sir.
One final question. You served for some time under Mr. Ehrlichman in the White House. For how long a period?
From April 8th, 1969 through July of 1970.
Did you see quite a bit of him during this time?
No, sir. I wouldn't characterize my time under Mr. Ehrlichman as frequent visits. I would be working very closely with his staff people, primarily Bud Crow, who had a variety of duties in the federal law enforcement area. And I would work primarily through Mr. Krogh into Mr. Ehrlichman.
But you were generally familiar with some of the missions or the work that Mr. Ehrlichman was carrying on in the White House. Is that fair to say?
Generally familiar, yes, sir.
Would you say that it was also a fair thing to say that Mr. Ehrlichman undertook a great many missions, a good deal of work in the White House, in his duties on his own independent carrying out? Is that a fair thing to say?
NPACT, Box 300, Washington, D.C. NPACT's coverage of the hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
And as the hearings resume, Republican Senator Gurney is questioning John Caulfield about his contact with the White House about messages to McCord.
Mr. Caulfield, your testimony certainly has been very full and very clear. I just want to press home one or two points. Referring to the previous testimony by Mr. McCord, page 320 of the record, he had this to say about his conversations and meeting with you. Caulfield stated that he was carrying the message of executive clemency to me from the very highest levels of the White House. He stated that the President of the United States was in Key Biscayne, Florida that weekend, referring to the weekend following January the 8th, the following meeting that we were in then, and that the President had been told of the results of the meeting. Did you ever learn that the President had learned of the results of any of your meetings with Mr. McCord?
Absolutely not, sir.
He also stated this further on in the testimony on the next page. Mr. McCord, he meaning you, further stated, quote, I may have a message to you at our next meeting from the President himself, close quote. Did you ever tell him that?
No, sir.
Did you ever have any communication with the President of the United States with regard to this so-called executive clemency offer to Mr. McCord?
None whatsoever, sir.
Did you ever hear Mr. Dean, in any of your conversations with Mr. Dean, ever refer to the fact that he had informed the President of any of these meetings?
No, sir.
Did Mr. Dean ever say to you, the President has instructed me to make this offer of executive clemency to McCord through you or through anybody else as far as that's concerned?
Absolutely not, sir.
Did you ever apply any pressure to Mr. McCord in any of these meetings for him to do anything in regard to this upcoming trial?
No, sir.
Did you ever urge him or advise him to plead guilty?
Never.
This point has been covered, but it is important because of Mr. McCord's testimony. My understanding is that your understanding about these calls to the embassy and the wiretaps on the embassy, that this was his theory of defense, a way that he could get out of it by having the case dismissed if these wiretaps had occurred. Is that correct?
That's correct.
Did Mr. McCord ever discuss with you whatever plans he might have if he were found guilty at the trial?
No, sir.
One final question. You served for some time under Mr. Ehrlichman in the White House. For how long a period?
From April 8th, 1969 through July of 1970.
Did you see quite a bit of him during this time?
No, sir, I wouldn't characterize my time under Mr. Ehrlichman as frequent visits. I would be working very closely with his staff people, primarily Bud Krogh, who had a variety of duties in the federal law enforcement area. And I would work primarily through Mr. Krogh into Mr. Ehrlichman.
But you were generally familiar with some of the missions or the work that Mr. Ehrlichman was carrying on in the White House. Is that fair to say?
Generally familiar, yes, sir.
Would you say that it was also a fair thing to say that Mr. Ehrlichman undertook a great many missions, a good deal of work in the White House, in his duties on his own independent carrying out? Is that a fair thing to say?
Well, of course, I have no way of knowing that, Senator.
Would that be your impression?
It's possible, Senator.
I don't have any further questions.
Mr. Caulfield, are you still on the federal payroll?
I'm in what they call administrative leave status because of these developments with the Treasury. Yes, sir, as of this moment, I'm still on the federal payroll.
You getting a check?
Yes, sir.
But you're on leave?
Yes, sir.
Did you call Mr. John Ehrlichman immediately after the break-in of the Watergate on June 17th?
Yes, sir.
What did he say?
Well, I received a telephone call on the afternoon of June 17th, which is the date of the break-in, about 3 or 4 p.m., as I recall, from a gentleman I worked with in the United States Secret Service, Mr. Patrick Boggs. And he called me and he said, do you know Jim McCord? And I said, yeah, I know Jim McCord. And he indicated, he said, well, we've received a report that there's a break-in at the Democratic National Committee. We're concerned because of our protective capabilities, or responsibilities rather, in that area. We have some agents checking into it. Some of the people appear not to have given their correct names. And we're getting a report that one of those not giving the correct name is Jim McCord. He said, now, do you want to call John Ehrlichman, or should I call him? After I had recovered from the shock, I indicated, well, you go ahead and try and reach him, and I'll try and reach him as well. And I called the White House board, and I was told that he was en route to his residence. By the time that I did reach him, Mr. Boggs had already contacted him. And I said to Mr. Ehrlichman, I said, John, it sounds like there's a disaster of some type. Did you speak to Mr. Boggs? He said, yeah, what's this all about? And I said, I haven't got the foggiest notion what it's all about, but they're saying They believe Jim McCord, who works for the committee, has been arrested in a burglary at the Democratic National Committee. So he said, I forget exactly what he said then, but I said, I think it was a long silence, as I recall. And I said, my God, you know, I can't believe it. He said, well, I guess I better place a call to John Mitchell. I said, I think that would be very appropriate.
Who said that it sounds like a disaster, you or Mr. Ehrlichman?
John J. Caulfield.
Now, why did you have Mr. Ulasewicz call Mr. McCord rather than calling him yourself?
In this July call?
Yes, this anonymous, mysterious call with a New York accent.
Now, are we talking about the January call or the July call?
Talking about the call with no name that Mr. Ulasewicz is alleged to have made at your request and the request of John Dean.
Oh, well, again, I didn't want to make the call, Senator. I knew how serious it was, how dangerous it was. I explained to John Dean that I didn't want to do it. I hadn't focused completely on the seriousness of the misconduct, but intuitively I knew that it was wrong, and I just didn't want to do it. And as I've indicated in my testimony, I tried to get out of it. And I felt that because I had asked Mr. Ulasewicz previously to set up this telephone arrangement with Mr. McCord outside of his residence, that he could, when Mr. McCord received the call, he would understand that it was coming from me. This was my way of getting the message delivered without getting involved.
Whom were you working for at the time you relayed Mr. Dean's message to Mr. McCord?
In January?
Yes.
I was the assistant director of the Bureau of Alcohol, Tobacco, and Firearms.
Now, on behalf of whom did you assume Mr. Dean to be speaking, or talking of, when he spoke of executive clemency for Mr. McCord?
Well, as I've indicated, coming from Mr. Dean, and having worked with him, I assumed that there were others at the White House that were involved in this matter in terms of the offer.
Who did you think was the real author of the message, Mr. Dean or someone else?
Well, sir, again, I believe that conceivably, very conceivably, that if we're going to talk about others, that quite possibly Mr. Ehrlichman. I have no way of knowing that, Senator.
Mr. Chairman, I have no further questions. Thank you, sir.
Mr. Chairman, thank you very much. Mr. Caulfield, I won't take very long. But necessarily, I expect the points I want further elaboration on and the questions I have may be at least in part repetitious. Do you have any idea why Mr. McCord chose you to send that letter to?
Well, of course I don't know, but Jim McCord knew I worked at the White House. He knew that I had worked for Mr. Dean.
The answer is you don't know. Did Mr. McCord ever tell you why?
No, sir, did not.
Did he confirm that he wrote the unsigned letter to you?
Yes, I think there was just a brief conversation about it in our first conversation in the car.
Did he indicate to you why he wrote the letter at all? You've told me now that he did not indicate why he chose you to write the letter to. Did he indicate to you why he wrote the letter?
I think in substance what he said was what was in the note. you know, the CIA is, White House is going to do this thing to CIA. I'm not going to stand for that.
Did he tell you why he thought the White House was going to blame this on the CIA?
No, sir, I have no recollection of that as to why.
He didn't elaborate on that point at all?
No, sir.
Did you have any indication or evidence or suspicion that the White House was trying to, quote, blame it on the CIA, independent of your conversation with Mr. McCord?
Senator, the whole letter was upset me quite a bit. You know, it was unsigned. I assumed it was Mr. McCord, and the last sentence bothered me.
Did you ask him why he thought they were going to blame it on the CIA?
No, sir.
Mr. Caulfield, it seems to me that a defendant in those circumstances, or a suspect who had been arrested on charges such as Mr. McCord had been arrested, have three possible alternative courses of action. I'm speaking now in the hypothetical sense. He can plead guilty. He can plead not guilty and defend himself on the facts. Or third, he can try to contrive a way to create circumstances which would result in his exoneration separate and apart from the facts. Would that be the range of possibilities that presented themselves to Mr. McCord at the time?
My judgment?
Yes, sir.
Yes, sir.
Now let's focus on the third. Obviously, he pled not guilty. This record has extensive reference to efforts allegedly to induce him to plead guilty and receive executive clemency, which he declined to do. He pled not guilty. He was convicted. But before his trial and conviction, or at least during the time of his trial and before his conviction, this conversation with you, as I understand it, and please excuse me for being repetitious, but I want to fix it clearly in my mind in relation to the alternatives that were available to Mr. McCord. At the time of this conversation, the trial was going on, or at least he hadn't been convicted yet. Is that correct?
That's my recollection, yes, sir.
The trial was actually in progress, was it not?
I'm not absolutely certain. I believe it was, but the dates are...
And Mr. McCord told you that he wasn't going to plead guilty, he wasn't interested in executive clemency, he wasn't interested in a year, that was a long time, that he wanted out free and clear. Is that the essence of it?
That's the essence of it, Senator.
And that he wouldn't settle for anything less.
That's right.
And that to achieve that end, he had arranged and contrived to phone 2 foreign embassies whose telephones he knew are suspected to be tapped, presumably illegally or at least embarrassingly to the United States government, so that logs of those calls could be subpoenaed by his attorneys and produced in court as evidence of illegal surveillance, so that the prosecution against him would have to be thrown out, or at least so that the government would be so embarrassed by these alleged taps on foreign embassies that they would dare not prosecute him further. Is that the fair intendment of what Mr. McCord told you?
Yes, sir.
Mr. McCord was holding hostage either the embarrassment of the United States government with respect to wiretaps on foreign embassies, or he's holding hostage the illegality of those taps on foreign embassies. Was that the thrust of his design for a defense at the time of that conversation?
That's my interpretation, sir, of his comments at that time.
Thank you very much.
Now, the trial had begun at the time you had these meetings with McCord in January. And presumably, McCord knew something about the conversations which were occurring between the defendants and their lawyers, did he not?
Presumably, Senator, yes.
And had you not read statements in the press or heard statements over the TV to the effect that since certain men, Barker and McCord, had previously worked for the CIA, that there was some suspicion the CIA was involved?
I think probably in the minds of many people at that time that was a suspicion. I don't know whether or not I suspected that, but...
Now, you, McCord, knew you were loyal to the president and also knew you were his friend, didn't he?
Yes, sir.
So he wrote you a letter which is susceptible of interpretation that he was giving you a warning that there was no validity to any claim that the CIA was responsible for the Watergate.
Yes, sir.
And did you not entertain the opinion after receiving that letter that McCord probably wrote it, believing that you would communicate its contents to Mr. Dean, at whose instance you had interviewed McCord?
Yes, sir. And I did just that.
And you did that?
Yes, sir.
Now, you testified under the questions of Senator White to the effect that your training as in law enforcement had given you a conviction that it was wrong to attempt to suppress testimony by an offer of executive clemency.
No question about that,
Yes.
Senator.
And also that you had a sense of loyalty to the president.
That's correct, sir.
And also that you considered Jim McCord your friend and appreciated the fact that he was in a very unfortunate situation, and you were motivated not only by your loyalty to what you thought was loyalty to the president, and by your assurance you received from Mr. Dean that if McCord did not go along with the other defendants and cooperate with his lawyer, that there might be a scandal against the president.
That's exactly right, Senator.
And so you were compelled to choose between your loyalties, and that was the reason you were willing to carry the message from Dean to McCord, notwithstanding the fact that you did not approve of offering executive clemency in return for suppression of testimony.
Yes, sir.
Well, it's a proof of what my old philosophy professor told me, that the greatest trials we have in this world is when we're compelled to choose between different loyalties, some of which are conflicting. And you were trying to protect the president, you were trying to aid your friend, and you were trying to carry out a mission which you accepted somewhat reluctantly from a man that you knew, that is John Dean, whom you knew to be the president's counsel, and whom you knew would be actuated by a desire to protect the president against any scandal.
Absolutely correct, Senator.
Sam, I have one brief question when you finish.
Yeah, just one thing. Now, when you went with this, performed this mission for John Dean on these three occasions, what did you expect, or rather, what did you understand was expected of McCord in return for executive clemency?
I believe that in terms of the context of the message, a year is a long time, but it would be sometime less than a year.
Did you infer from your conversation with Dean, under Dean's statements, that McCord was expected to plead guilty, keep silent, receive a short sentence, and then receive clemency?
If he accepted the offer, that would be the way I would interpret it. Yes, sir.
Now, you were asked a question if Mr. Ehrlichman did not sometimes do things on his own accord, on his own authority. For whom was Mr. Ehrlichman working?
Mr. Ehrlichman was working for the President of the United States.
Do you know of your own knowledge of any time that Mr. Ehrlichman did things on his own accord, out of his own head and imagination?
I'm sure he has many times, Senator.
No. And are you unable to tell when he was acting on the instructions or when he was acting out of his own head and imagination?
No, sir. If I were given an assignment, I'd go ahead and do it.
And when you called Mr. Ehrlichman shortly after the break-in, I believe you think it's sometime about July, Mr. Ehrlichman told you he thought he'd better call John Mitchell. You said you thought it would be a good idea.
Yes, sir.
And John Mitchell at that had been the Attorney General, and at that time had just resigned as director of the committee to re-elect the president a short time before.
Yes, sir.
That's all.
Mr. Chairman, might I ask one more question?
Yes, sir.
Mr. Caulfield, you've testified at length and extensively about matters of great importance in which you had a direct involvement.
I beg your pardon, Senator, I'm sorry.
Mr. Caulfield, you've testified at length and extensively about important matters in which you had a direct involvement.
Yes, sir.
You're aware of the nature of those transactions.
Yes, sir.
And the possible consequences from them.
Yes, sir.
Mr. Caulfield, have you ever been requested to, or have you ever suggested that there be any claim of executive privilege on your behalf?
No, sir.
Have you ever requested immunity from prosecution from this committee, a grand jury, or anyone else with respect to the information that you've given us?
Absolutely not, sir.
Thank you, sir.
I want to thank you for appearing before the committee and for your testimony. And with the understanding that you will return later at the request of the committee while excused at this time. Thank you very much.
Will Mr. Anthony Ulasewicz please come to the witness table, please?
Would you raise your right hand? Do you swear that the evidence that you shall give to the Senate Select Committee on presidential campaign activities shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. My name is...
Have you seated, Mr. Ulasewicz?
Yes.
Mr. Ulasewicz, for the record, would you please state your full name and your address?
My name is Anthony, middle initial T, last name is Ulasewicz, U-L-A-S-E-W-I-C-Z. I reside in the town of Day, D-A-Y, Saratoga County, in the state of New York.
And you are appearing alone and without an attorney?
Yes, sir.
Now, Mr. Ulasewicz, I understand it that you had a police career. Would you please give us that professional background?
Yes, I was appointed to the New York City Police Department February the 17th, 1943, and left the department on or about July the 9th of 1969. I was a detective first grade in a command known as the Bureau of Special Services and Investigations of the New York City Police Department. I spent 21 years in that command. 6 years prior were in uniform.
Could you just briefly describe what your functions were in that assignment?
The Bureau of Special Services investigations conducted investigations regarding groups and organizations within the city who might be a problem at any time. These were groups, perhaps dissident groups with governments in their own background nations. We provided security for visiting personages and any causes for demonstrations that might result in some difficulty to the city.
How long have you known Mr. John Caulfield?
For about 10 years.
And did you meet him during your services in the police department?
While I was in the Bureau of Special Services, Mr. Caulfield became part of the command for some time and then left for another command, and that's how we started our friendship.
Now, in July of 1972, did you receive a call from Mr. Caulfield?
In June of 1972.
June of 1972. And can you just briefly tell us what the nature of that call was?
Yes. Mr. Caulfield called me somewhere about the 25th or 26th of June and asked me to come to see him in Washington, D.C. the next day on a personal matter. I met with him around noontime. He mentioned that he was thinking of contacting Mr. McCord, a friend of his, that he did not have his telephone number. It was unlisted, had been changed. And he said, would I assist him in arranging for an appointment so that he may speak, not meet, but speak with Mr. McCord.
And then what did you do?
I said, all right, if you don't know any other, if you want my help, I'll do it. I didn't question in any way. he asked me how could I do it as soon as possible, and I said, I'll do it right now. And I said, number one, you'll have to give me some kind of identifying information. How will Mr. McCord know that it's you that's contacting him? And what I did was I wrote a note on a plain piece of paper and told Jack I would deliver that to Mr. McCord, setting up a telephone, and he can then have his conversation. The purpose of this call, he said he wanted to help Mr. McCord, express his sympathy, etc. They had been such good friends in the past. I wrote a note, arranged, I told Jack that I must have some identifying information so that this thing would, that Mr. McCord would believe it is he. He said, well, there was an incident recently in which Mr. Caulfield left his raincoat somewhere, and I put that in, that was the identifying information that I'm calling from, that I'm a mutual friend for whom you recovered a raincoat.
And did you, in fact, take that note? And,
yes.
And where did you deliver it?
I went to, I proceeded immediately to the area where Mr. McCord resides. Mr. Caulfield had given me the address. I looked around through the area, located a place, a Blue Inn or something, which has a large parking lot and 2 telephone booths isolated by themselves. I took the 2 telephone numbers of the booth, put them on the note, put two different times, like 2:30 and 4:30, and then I wrote on the note about a mutual friend wishes to speak to you, or words to that effect. You recently recovered a raincoat of his. It was not signed. I took I then proceeded, this telephone booth is within the vicinity, of course, of Mr. McCord's residence. I then took the note, I went to Mr. McCord's residence, placed it in the letterbox, and walked away. I then called from some area not too far. I called Mr. Caulfield and informed him that it was done.
Now later, in January of 1973, did you again receive a telephone call from Mr. Caulfield?
Yes, I did.
And from where did you know, or did he indicate he was calling?
He was indicating he was calling from California. I think it was a San Clemente Inn in California.
And what, if anything, did he tell you in that telephone conversation?
Well, he indicated to me that he wished another favor concerning Mr. McCord. He would like me to contact Mr. McCord and deliver a message. And as Mr. Caulfield says, there was a loud silence. I said, Jack, you realize that what you're asking is a very unusual request for many reasons. The timing, it's a different situation than it was in June, prior to it, etc. He said, Tony, or something to this in response. You know, I'm here on meetings, I'm conducting meetings, I'm very busy, there's interruptions. I can't do a thing like this from here. It would be very inconvenient. I know that what I'm asking is I wouldn't do it except that I know you're a friend and I can ask you to do it. He says, I wouldn't ask anyone else. I don't know who else I could ask. He said, things are being pushed on me. I don't want to get into it, or I wouldn't ask you to do it. If it ever does, I said something that, well, Mr. McCord, of course, being a good wire man, Jack, anything that's said to him, you can be expected, is probably recorded. He said, if this ever comes out, I will definitely admit that I asked you to do this and under these circumstances and on a friendship basis.
What was the
message to the
message that Mr. Caulfield asked you to give Mr. McCord?
To the best of my recollection, was in 5 or 6 phrases. It was, let's see now, I don't have the original notes. I wrote the phrases lightly after I agreed. And it was a year is a long time. No one now knows how a judge will go. Your family will be provided for. Rehabilitation and job opportunities will be provided for. During this conversation, which incidentally occurred in a telephone booth in the town of Day, and the telephone system is not the best. it wasn't too clear, and I thought Mr. McCord asked me to repeat something.
Is this, right now I'm asking you to recall the message or the telephone call you had from Mr. Caulfield.
This is it.
Yes.
Oh, to Mr. Caulfield?
No,
No, this is to
Mr. Caulfield asked you to tell Mr. McCord.
Oh. Well, I finished with Mr. Caulfield, and he gave me the number, and I then went in and made this call to Mr. McCord.
Yes, but the message that you did give to Mr. McCord was not your own message, was it?
Oh, no, it was Mr. Caulfield's message.
I take it the message you gave to Mr. McCord was the same message Mr. Caulfield asked you to give him.
Same message, yes, sir.
All right, then you can go ahead and say what you told Mr. McCord, but before that, how did you contact Mr. McCord?
Mr. Caulfield gave me the telephone number to Mr. McCord's residence. I did not have that number, so he provided me with the number. But I did have, I told him I would check that I still have those numbers to the telephone booths, and I did have those, and I contacted Mr. McCord at his residence. Mr. McCord was not surprised with the phone call, apparently, and said, yes, he'll go to the phone. And he went to the telephone booths, which were identical to the ones in the June message.
All right, then, now, Mr. McCord did come to the telephone booth. Did you call him, or did he call you?
No, I called Mr. McCord.
All right, and you did reach him at the other
end.
And
I did reach him, right.
All right, now, what, if anything, then, now, did you tell him that Mr. Caulfield asked you to tell him?
Right, I told him that I had a message from Mr. Caulfield, and that I went into this message of, as I just said, a year is a long time. No one knows how a judge will go. Your family needs will be provided for. Rehabilitation and job opportunities will be provided for. In the course of the conversation, Mr. McCord said something I didn't quite understand. I repeated a phrase or two of this. And there was something about, I don't know whether he asked me on plead guilty or was that part of my message. And that's all I recall of the message.
Do you recall saying anything about immunity, not to take immunity? Did immunity come up in the discussion?
I don't recall. It may very well have. I have heard Mr. McCord's testimony here, of course, as everyone has, and I searched my mind very strongly on a matter because I still believe Mr. McCord could have been taped and might have it on tape. I don't know. But knowing that possibility, I certainly searched my memory. And this is the best I can remember.
Right, and it is possible, and you're searching your memory, that the idea of pleading guilty came up during the conversation.
It's quite possible it might have been there.
Yes. Now, what did Mr. McCord say after you gave him that message? And by the way, when you gave him that message, did he know who you were?
No, I never met Mr. McCord in person prior at any time.
Did you identify yourself by name?
No, I went right into that I have a message from Jack Caulfield, and his response indicated to me that he was expecting a message, apparently. And I went right into it, and he thanked me and seemed satisfied.
And then what did you do after that?
I called Mr. Caulfield back in California, told him I relayed the message that he had given me, and that Mr. McCord did not seem surprised, and that he seemed satisfied.
All right. Did you have any other contact with Mr. McCord on the telephone?
The next day, Mr. Caulfield called me again and asked me to once more deliver a message to Mr. McCord.
And what was that message?
And that message was, Mr. Caulfield said to me that to explain, to make sure that Mr. McCord realizes that he's in California, that Mr. Caulfield's in California, that he will meet with him as soon as he returns, first order of business from California, to set up a tentative, a meet on the second overlook on Washington Highway, or Parkway, and to get that message to him and then call back and verify it.
Did Mr. Caulfield pick that particular location?
Yes, he did. And he said that he knew I wasn't familiar with that area, but he said McCord would know the area.
Right. And then were there any other contacts you had on the telephone?
Mr. Caulfield called me once more after that and said that he had planned to leave a day earlier. His plan, however, was delayed. Would I tell Mr. McCord that as soon as he lands, that same evening he will contact Mr. McCord and try to meet him immediately rather than the following day as I had originally conveyed my message.
What did Mr. McCord respond to that?
Mr. McCord was very annoyed. He told me, he kind of brushed me off, said, I have people here, I have my own family problems, you're doing what you think is right, something to that effect. He was talking kind of rapidly, and said, you could tell Jack that I will meet only as originally scheduled, meaning the second call, on the Overlook on the Washington Parkway.
Did you report that back to Mr.
No,
Caulfield?
I couldn't report that one back to Mr. Caulfield.
Was that the last contact?
That was the last contact I had on this matter with either of the two gentlemen.
All right. I have no further questions, Mr. Chairman.
Senator Blake, excuse me. Yeah, you go ahead.
Mr. Ulasewicz, was not Mr. Ehrlichman responsible for your being hired originally at the White
Yes, sir.
House? Did he direct your work while you were at the White House?
Mr. Caulfield directed my work.
He did. Was that at the, in turn, at the direction of Mr. Ehrlichman? Did he direct Mr. Caulfield?
That was my impression.
All right. Between the first telephone call that you made to Mr. McCord until after the trial, did you discuss the calls that you were making with Mr. Ehrlichman or anyone else at the White House?
No, sir.
You only discussed these matters with Mr. Caulfield?
And no one at any time.
All right. Did you see your role as someone who was delivering certain words which you took down, say, in writing and repeated? Or did you see your role as someone who was supposed to engage in conversation with Mr. McCord and paint a picture for him, so to speak?
Absolutely not. Strictly as a messenger to get the phrases over to him, and I originally did not repeat them in their full context from Mr. Caulfield. As my recollection is, I gave mass phrases.
All right. When Mr. McCord responded to those words, did you engage in conversation with him then?
No, sir.
According to your best recollection, was there ever any discussion between Mr. McCord and yourself about the fact that he should not testify at the trial?
I do not recall that.
Was there ever any discussion, to the best of your recollection, between Mr. McCord and yourself that he should plead guilty?
It may have been. I don't recall.
Well, if it may have been, would this have been in your original message, or would this have been pursuant to a conversation?
No, it would have been in the original message, which was that only time, only that first call.
All right. Now, this was not in your direct testimony. This was not a part of your direct testimony. Is it your opinion that it was not in your original message, or that it possibly could have been?
It could have been in the original message.
So you really don't remember what you told him?
Oh, from the best of my recollection, these three phrases are positive about the message be about a year is a long time, no one knows how a judge will go, your family needs will be provided for, rehabilitation and job opportunities. When there was a pause, there may have been something on the plead guilty or so, but I was giving the message as rapidly as I could as I wanted to finish the matter.
Pardon me, you say that may have come about or discussed when there was a pause.
Yeah, Mr. McCord said something that I didn't quite understand, so I repeated my message.
Well, this pause, would this still have been part of your original message? Or
original message. These only came in the original, any discussion of the, regarding the judge and all that business came only in the first conversation. The second conversation was to make the appointment. And the third conversation was to inform him that Mr. Caulfield will try to get to him a day sooner.
You did not seek to interpret in any way what the message meant?
No, sir.
To Mr.
No,
Ford.
sir.
Did Mr. Caulfield ever tell you who was directing him in this matter?
He did not.
I have no further questions, Mr. Chairman.
Yes. Didn't you infer? In other words, you made the statement to Mr. McCord, which Mr. Caulfield had asked you to make.
Yes, sir.
Wasn't it implicit in that statement that he would get these advantages if he entered the plea of guilty?
I would assume so, yes.
Definitely.
You certainly didn't construe this statement that he's going to be rehabilitated and given a year in,
No,
serve
sir.
only a year in jail and get all this fine treatment if he fought the case.
Absolutely. I didn't mean to infer any such thing, definitely.
Senator Baker? If not, I'll pass direct to Senator Gurney and then to Senator Taylor.
Mr. Chairman, I don't have any questions of the witness.
Mr. Lasowitz, had you been aware of the Watergate affair at the time you were asked to make
Yes,
this
sir.
call? Why did you agree to serve as a contact in this situation?
Because of my friendship with Mr. Caulfield, and in his original call to me, with my arguments of why I didn't want to, his demeanor, his conduct, I could see it was very important to him. He was in some kind of a position that caused him great concern, and as friends, I said I would do it.
Did you assume that Mr. Caulfield's authority was coming from high authority in the White House?
I assumed it was coming from at least Mr. Dean, somebody above Mr. Caulfield.
Did you believe that these White House sources would approve of what you did?
Yes, I suppose so.
Were you paid for your services in contacting Mr. McCord?
No, sir. I was on no one's payroll at the time of these conversations in January. I was not in anyone's employ, I meant to say.
I have no further questions at this time, Mr. Chairman.
Senator White.
No questions, Mr. Chairman.
Thank you very much. According to Mr. Caulfield's testimony, you were a member of a, quote, private security entity in Washington, D.C. for the purposes of providing investigative support for the White House. Is that correct?
That's correct.
You worked under Mr. Caulfield, but was on the payroll of Mr. Kalmbach?
That's correct.
What were you receiving as salary from Mr. Kalmbach?
$22,000 a year plus expenses.
Are you still on Mr. Kalmbach's payroll?
No, sir.
When were you taken off the payroll?
In 1971, well, to the end of the year of 72.
What was the nature of your work?
It was supporting, as an outside supporting investigative to Mr. Caulfield.
Can you describe some of your activities? One of the newspapers described you as the super spy. Is that a correct
The newspapers have painted quite a few pictures of me recently, but I was no spy, of course, of any kind. I did investigative work in support of whatever Mr. Caulfield related to me. I did no slanderous spying, as newspapers, allegations, etc. I can best put it in its category, probably, as supporting anybody that's conducting legitimate investigations. I used no wiretaps. I never used any surveillance, etc.
You consider your work to be legal?
Absolutely legal, yes, sir. When I left the police department, I left a fine ongoing career not to get involved in anything illegal. And I made that a stipulation with Mr. Ehrlichman at the time the job was taken.
But
Mr. Caulfield would certainly know I wouldn't go for it.
But in this very special assignment which you received from Mr. Caulfield to serve as contact with Mr. McCord, were you aware that you were an accessory to the commission of the crime to
Yes, sir.
obstruct criminal investigation?
I knew that it was wrong.
You knew that you were an accessory to a crime?
Yes, sir.
But as a matter of friendship, you proceeded?
Yes, sir.
Did you have other assignments of similar nature?
No.
I have no questions, sir.
Thank you, Senator Noya. I might say that the question hasn't been asked you, but I'll put it now. While we're limiting our inquiry to a single set of events and circumstances, do I understand that you're willing to return and to testify further at the pleasure of the committee on other matters that you may have knowledge of?
Yes, sir.
Very good. Senator Montoya has no questions. Let me ask just one question then, if I may, or one line of questions. It really doesn't bear much on the matter at hand, I suppose, but did I understand you to say that McCord was a pretty good wire man?
Well, yeah, from what I've read of the case, and from the fact that Mr. Caulfield hired him, I would say he was one of the best wiremen in the business.
Well, I'm not familiar with the term. What do you mean, a pretty good wireman?
Well, a wireman in police parlance would be anyone who's familiar with applying wiretaps, any type of surveillances by electrical means and so forth. Well, in a room, on a person, in an automobile, in a tire, any place. And I would say that he was a good man.
Is that a term in general usage in,
yes, sir.
In your trade?
Yes, sir. However, I was never a wireman. Well, while we were in the police department, many of the functions that we did, of course, they were all legal and with proper papers, et cetera, and judicial permission. We have some of the finest wiremen in the department, and so it would be a thing of common knowledge to myself or anyone else.
You think your wiremen were better than McCord's wiremen?
Well, I tell you, there would no retired man in the New York City Police Department would be coming involved in a thing like that. And if he thought he had to, for whatever reason it was, he wouldn't have walked in with an army. That's for sure.
He wouldn't have walked in with an army. Would he have walked in with identification papers and serially numbered $100 bills and an address book?
He would have probably walked in like any decent, common-looking citizen, laid something in the right place, and walked right out, and that would have been the end of it for a long time.
How could you?
Well, they say you must be honest here, Senator.
Yeah,
right?
how could... How could you have gained the information? How could you have gained the information that Mr. McCord obviously or apparently was seeking, that is, telecommunication link with what was going on in the Democratic National Committee, without going in there with an army and taping the doors and all the rest? Describe to us how else that might have been done by a good wireman.
Well, a wireman would only do wires. He might not necessarily be a good man for a different type of an investigation. If it's a question of obtaining information from a Democratic Party, Republican, or anybody else, the easiest way is to write a postal card and ask them to mail you all their leaflets. They'll put you on, and forever you'll have everything. Even after it's over with, you'll still get it. They're very happy to do so.
You mean politicians are pretty anxious to add to their mailing list?
And the politicians are most vulnerable people in the world, in my experience in the last 3 years, to any kind of scandal, et cetera, and et cetera.
Well,
I don't say they're guilty of it, because I still have to come back here. But because of the type and
the last thing on earth I'd want to do is to convert your testimony into self-serving purposes for this committee. But you don't have any good wiremen on us, do you?
It looks like there's plenty of them here.
Well, you know, that's not a very good answer. You're heightening my concern rather than lessening it.
I have none on anybody. Thank you.
Thank you.
You can cover that. I'm not coming back. Yeah. I understand that you will come back when the committee requests you for further evidence.
Definitely, Senator.
Thank you, sir. Thank you very much. I think it's almost recess time, and I believe it'd be better to recess this point to 2 o'clock and then start on the next witness stand.
Very good.
Former New York policeman Anthony Ulasewicz has explained for the committee how he aided Treasury Department official John Caulfield in trying to convince James McCord to go along with a game plan being adhered to by the other Watergate defendants. Several members of the committee have made it clear they would like to invite Ulasewicz back to talk about some other points that came up during today's testimony. But for the moment, though, the probe is centered on how McCord was defended and what sort of deal he was offered. This afternoon, there will be another side to the story as Gerald Alch, McCord's former attorney, tells his side of the story, and it is significantly different from McCord's. Impact's hearing coverage continues after this station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
Gerald Alch, McCord's original lawyer, is now taking the stand to explain his reading of their relationship.
The chairman had asked me to announce that he is on his way from a meeting of the Judiciary Committee, which, as you know, is considering the nomination of Mr. Elliot Richardson to be Attorney General of the United States, that he and Senator Gurney, a member of the Judiciary Committee, will be here momentarily. He asked me, however, in the interest of time, to convene the committee and to proceed with the opening statement, which we understand Mr. Alch is now prepared to give.
All right. I see Mr. Gerald Alch is at the witness table. Would you, Mr. Chairman, swear the witness?
Mr. Alch, would you hold up your right hand?
Yes, sir.
Would you please state your name?
Gerald Alch.
Mr. Gerald Alch, do you solemnly swear that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated.
Now, the committee has been supplied 13 pages of the statement that Mr. Alch will be reading. Our committee staff has done the typing and reproducing of this for Mr. Alch after having been supplied a copy of his statement, and the rest of it will be available to the committee during the course of the reading of the statement. Mr. Alch, for the record, would you give your full name and address?
Yes, sir. My name is Gerald Alch, A-L-C-H. My address is 954 West Roxbury Parkway, Chestnut Hill, Massachusetts.
And you did prepare a statement which you wish to read to this committee.
Yes, sir.
Would you proceed in reading that statement?
Thank you, and I will. May it please this honorable committee. In all candor, I am about to testify with a certain degree of regret. This is because those areas to which I shall address myself are areas which I, as a criminal defense attorney, believe to be somewhat sacred. They reflect conversation between a lawyer and his client, uttered in the course of a relationship wherein I was exerting my best efforts to protect the interest and welfare of James W. McCord. I take most seriously the well-established attorney-client privilege. Nevertheless, in my judgment, Mr. McCord, in his testimony before this honorable committee on Friday, May 18, 1973, and in other prior disclosures, both written and oral, has waived such privilege, which I have been informed he has acknowledged. Mr. McCord has made allegations concerning my conduct in the defense of his liberty. These allegations are, in some instances, completely false, and in other instances have been twisted out of context into untruths, presumably to serve his present purpose, whatever that may be, but which impugn my personal standards of ethical and legal behavior. I accordingly believe it now to be my duty and responsibility to respond, and I have accepted the invitation of this honorable committee so to do, for which I am most grateful. Here, then, is a true narrative of my representation of Mr. McCord. In July of 1972, my office received a telephone call from Mr. McCord requesting an appointment. On a Saturday morning during that month, I met with him for the very first time. He identified himself as one of those arrested in the Watergate building on June 17, 1972. He told me that he had taken a calculated risk in doing what he did and was prepared to face the consequences. Within that framework, however, he indicated he wanted the most effective legal representation possible and asked whether or not my partner, Attorney F. Lee Bailey, would be interested in representing him. I told him that I had advised Mr. Bailey of my appointment with him and that he, Mr. Bailey, was not interested in representing any defendant.
Coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
Gerald Alch, McCord's original lawyer, is now taking the stand to explain his reading of their relationship.
The chairman has asked me to announce that he is on his way from a meeting of the Judiciary Committee, which, as you know, is considering the nomination of Mr. Elliott Richardson to be Attorney General of the United States, that he and Senator Gurney, a member of the Judiciary Committee, will be here momentarily. He asked me, however, in the interest of time, to convene the committee and to proceed with the opening statement, which we understand Mr. Alch is now prepared to give.
All right, I see Mr. Gerald Alch is at the witness table. Would you, Mr. Chairman, swear the witness?
Mr. Alch, would you hold up your right hand?
Yes, sir.
Would you please state your name?
Gerald Alch.
Mr. Gerald Alch, do you solemnly swear that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated.
Now, the committee has been supplied 13 pages of the statement that Mr. Alch will be reading. Our committee staff has done the typing and reproducing of this for Mr. Alch after having been supplied a copy of his statement, and the rest of it will be available to the committee during the course of the reading of the statement. Mr. Alch, for the record, would you give your full name and address?
Yes, sir. My name is Gerald Alch, A-L-C-H. My address is 954 West Roxbury Parkway, Chestnut Hill, Massachusetts.
And you did prepare a statement which you wish to read to this committee.
Yes, sir.
Would you proceed in reading that statement?
Thank you, and I will. May it please this honorable committee. In all candor, I am about to testify with a certain degree of regret. This is because those areas to which I shall address myself are areas which I, as a criminal defense attorney, believe to be somewhat sacred. They reflect conversation between a lawyer and his client, uttered in the course of a relationship wherein I was exerting my best efforts to protect the interest and welfare of James W. McCord. I take most seriously the well-established attorney-client privilege. Nevertheless, in my judgment, Mr. McCord, in his testimony before this honorable committee on Friday, May 18, 1973, and in other prior disclosures, both written and oral, has waived such privilege, which I have been informed he has acknowledged. Mr. McCord has made allegations concerning my conduct in the defense of his liberty. These allegations are, in some instances, completely false, and in other instances have been twisted out of context into untruths, presumably to serve his present purpose, whatever that may be, but which impugn my personal standards of ethical and legal behavior. I accordingly believe it now to be my duty and responsibility to respond, and I have accepted the invitation of this honorable committee so to do, for which I am most grateful. Here, then, is a true narrative of my representation of Mr. McCord. In July of 1972, my office received a telephone call from Mr. McCord requesting an appointment. On a Saturday morning during that month, I met with him for the very first time. He identified himself as one of those arrested in the Watergate building on June 17, 1972. He told me that he had taken a calculated risk in doing what he did and was prepared to face the consequences. Within that framework, however, he indicated he wanted the most effective legal representation possible and asked whether or not my partner, Attorney F. Lee Bailey, would be interested in representing him. I told him that I had advised Mr. Bailey of my appointment with him and that he, Mr. Bailey, was not interested in representing any defendants in this particular case. Mr. McCord told me that as a result of his impression of me, he desired my counsel. A fee of $25,000 plus expenses was quoted and agreed upon by Mr. McCord. Arrangements were made for the payment of this fee over a period of time, which arrangements were ultimately met by Mr. McCord, although over a longer period of time than originally agreed upon. I asked Mr. McCord to give me specific details attending the Watergate break-in, but he specifically declined to do so, except to state his personal motivation for so acting. That is, as he told it to me that first meeting, the protection of others. I explained to him that since he had been physically apprehended in the Watergate complex, he could obviously not deny that fact, and inquired as to his motivation in so acting. He told me that as Chief of Security for the Committee to Re-elect the President, he had received information to the effect that various anti-war demonstrations by groups which he described as radical were being planned for the upcoming presidential election, and that these demonstrations had in the past and would invariably in the future lead to violence or the threat thereof to various prominent Republican officials, including but not limited to members of the Committee to Re-elect the President, and including but not limited to the President of the United States. I told him that I would explore whether or not this motivation could in any way be embraced by a recognized legal defense. He told me that he wished me to come to Washington, D.C. and meet with an attorney by the name of Paul O'Brien, whom he described as one of the counsel to his employer, the Committee to Re-elect the President. He desired that I contact Mr. O'Brien and advise him of his, Mr. McCord's, position. Shortly thereafter, I traveled to the Capitol and telephoned Mr. O'Brien for an appointment. Mr. McCord drove me to Mr. O'Brien's office, whereupon I met with Mr. Bryan and a gentleman introduced to me as Mr. Kenneth Parkinson. I introduced myself, told Mr. O'Brien I had been retained to represent Mr. McCord, and it was here at Mr. McCord's direction to inform him as a representative of Mr. McCord's employer, the Committee to Re-elect the President, that Mr. McCord was, as he had told me, prepared to face the consequences of his acts. Mr. O'Brien and I exchanged office telephone numbers, and the meeting, which had lasted for approximately 15 minutes, terminated.
My first official act on behalf of Mr. McCord was to represent him at a pretrial indictment probable cause hearing before a Superior Court judge in the District of Columbia. All other defendants had waived such a hearing, but I decided to utilize it as best I could for discovery purposes. Mr. McCord was most impressed with my in-court presentation, and he told me so. I subsequently accompanied him, his wife, and daughter before the federal grand jury. At one point, prior to indictment, I was advised by the prosecutors, Mr. Earl Silbert and Mr. Seymour Glanzer, that they possessed independent evidence that equipment utilized in the monitoring of telephone conversations from the office of the National Democratic Committee had been delivered to Mr. McCord's home in the presence of Mr. McCord's wife on the night of June 17, 1972. They advised me of the possibility of Mr. McCord's wife being indicted as an accessory after the fact, but indicated that this would not be done if the equipment was produced. I discussed this with Mr. McCord, and he requested me to work out the best arrangement possible, but to do anything and everything to protect his wife, whom he said had no involvement in his activities. Accordingly, an arrangement was agreed upon with the prosecutors whereby the equipment was surrendered to them with the agreement that they would not divulge during trial the fact that this particular equipment was obtained from Mr. McCord. Mrs. McCord was not indicted, and the government kept its word with regard to the manner in which said equipment was introduced during trial. In the ensuing weeks and months, during my many contacts with Mr. McCord, he continuously insisted that his only purpose in participating in the Watergate break-in was to protect his employers and other Republican officials from threats of violence. He would almost daily send to me clippings from various newspapers published throughout the country, reflecting reports of anti-war group activities which in some instances involve violence. In fact, at one point, he sent to me a typed memorandum reflecting this alleged motivation for his conduct, which memorandum included various legal citations of law, which he believed to be in support of the defense he wished me to present. I have made available to this honorable committee copies of 3 such memoranda, one of which was accompanied by a handwritten note from Mr. McCord, which reads as follows, dated July 13, 1972. Gerald, I well understand that it is your job and not mine to work up a defense. Nevertheless, I have been putting together some ideas and collecting every newspaper clipping I can find, which may be of help later. I am strongly oriented toward the grounds of self-defense and defense of others and of property as my defense. I believe we can make the strongest defense on these grounds. We will, of course, have to talk this out at length, and you have the final say in this matter. With best regards, Jim. I read this, may it please this honorable committee, to emphasize this fact, that Mr. McCord was from the beginning in complete agreement with the defense ultimately presented in his behalf. At no time did he ever state to me that he believed the Watergate operation to be legal as a result of the alleged involvement of the then Attorney General, the counsel to the President, or anyone else. As a matter of fact, during one of my many conversations with Mr. McCord on this subject, I told him that my legal research revealed that the defense of the protection of others required that the perpetrator not know he was breaking the law. I said to Mr. McCord, Jim, no jury will ever believe that a man with your background, with the FBI and the CIA, would not realize he was breaking the law in breaking into an office at night, wearing surgical gloves, and armed with eavesdropping equipment. He laughed and agreed that such a contention was in fact legally untenable. I further explained that the reason for his actions, as he had explained them to me, would be more properly embraced by the legal defense of duress, wherein the perpetrator felt compelled to break a law in order to prevent a greater evil. Mr. McCord had explained to me his belief of a direct relationship between these potentially violent anti-war groups and the Democratic Party, and that his participation in the Watergate burglary was accomplished in the hope of obtaining advance evidence of planned, potentially violent demonstrations. I advised that the law of duress allowed for the perpetrator to possess criminal intent, that is, to know that he was breaking the law, and that therefore, based upon what he had told me with regard to his own motivation, this defense was not only compatible therewith, but in my opinion, constituted the only defense available. Mr. McCord wholeheartedly agreed, and I commenced to prepare the case on this basis. I also received from Mr. McCord an outline of a proposed book he was in the process of writing, entitled Counter-Espionage Agent for the Republicans, The True Story of the Watergate Case. It was an outline listing such chapters titled The Beginnings, The Committee to Re-elect the President, Background to Violence and Political Espionage, Jack Anderson, the man who brought you the Eagleton case, The Political Opposition, The Watergate Incident, The True Story, The Defendants, The Grand Jury, The Lawyers, The Investigators, The Congressional Committees, The October Phase, The News Media, The Final Story, with a prologue, as the book goes to print, if the Democrats had had alarms and guards. Copies of this outline have also been provided to this honorable committee. All of these memoranda, I may add, gentlemen, were provided to me by mail directly from Mr. McCord. In this regard, on September 19, 1972, one of my associates from my office, Mr. John Albert Johnson, appeared with Mr. McCord for arraignment before Chief Judge Sirica, since I had a court commitment in another state. Mr. McCord told Mr. Johnson that he was in the process of writing a book and desired our opinion as to whether he could have this book published prior to Election Day. He told Mr. Johnson that he felt that any publication after Presidential Election Day would not be worthwhile monetarily. Mr. Johnson reduced this conversation to a file memorandum, copies of which have also been presented to this honorable committee. When Mr. Johnson advised me of this, I told Mr. McCord that, in my opinion, no such publication should be contemplated prior to trial. Mr. McCord, reluctantly it appeared to me, agreed to follow my advice. There were other memoranda that I received from time to time from Mr. McCord, which suggested for consideration other potential defense material which I rejected. One such memorandum, copies of which have been provided to this honorable committee, listed and discussed such topics as, and I quote, the Mafia and Democratic National Committee funds and personnel, unquote. Quote, Flying Tigers and Anna Chenault, unquote. Quote, Israel and the Mafia, unquote. Said memorandum, as you honorable senators will note in the copies provided to you, also mention names of other individuals and law firms, which names I choose not to bandy about in this public hearing. On several occasions, Mr. McCord told me that he was convinced that there existed a concerted effort on the part of his co-defendants and their counsel to make him the fall guy of the Watergate operation. On one particular occasion, he mailed to me a memorandum, copies of which you also have, reflecting his belief. Said memorandum reads as follows. Dated October 16, 1972, subject, shift of focus of the publicity. Jerry, about a week ago, Newsweek reporters told one of my men that the FBI had been leaking information to them relative to my case, and some of the material would appear in the next 2 issues. Last week, one item appeared regarding an office of mine rented on K Street, D.C. This week's issue, October 23rd in date, carries for the first time an allegation that I was the, quote, ringleader, unquote, of the Watergate operation. Instead of being 4th down the ladder from Liddy, Hunt, and Barker, I am now the, quote, ringleader, unquote, according to the FBI. This had been predicted, that I would try to be made the focus in order to draw the attention away from the WH men, Liddy and Hunt. I could see it coming as early as August, and more particularly 2 weeks ago when you and I talked. The FBI leaks to Newsweek are no accident. It is as predicted. Jim. I advised Mr. McCord that I had kept abreast of newspaper coverage of the Watergate incident and that in all honesty I could discern no effort on anyone's part to foist upon him prime responsibility for the offenses charged. He disagreed with me, and I told him that I would subsequently discuss the matter with other defense counsel. At another time, prior to January 1973, Mr. McCord advised that he had made telephone calls to the Israeli embassy on September 19, 1972, and to the Chilean embassy on October 10, 1972. He did not divulge the contents of these telephone conversations. He explained his purpose as follows. He told me he was convinced that the government had telephone taps on the phones of these embassies, but would not admit to such activity. He was certain that his calls had been intercepted. He instructed that I make a motion in court requiring the government to disclose any and all intercepted communications in which he was involved. His theory was that the government, rather than reveal such activity, would dismiss the case against him. I asked him what these calls were about. He told me that they were phone calls relative to the case. I now understand that these phone calls were not of any relative substance, which fact Mr. McCord had not told me originally. I received a letter from him dated August 23, reflecting these thoughts, copies of which I have made available to this honorable committee. It is a two-page letter, and in the interest of expediency, I shall not read the letter in its entirety. It deals with the subject of the consequences of the government intercepting telephone calls. However, I would respectfully call to the attention of this honorable committee the last paragraph of the letter, which reads as follows, and I quote, "Enjoyed the visit with you and appreciated your advice. I've got a great lawyer and am well aware of that fact. With best regards, Jim." In addition, I have provided this honorable committee with copies of an undated memorandum from Mr. McCord reflecting 4 telephone calls, one from Chile to Mr. McCord's office, another from Mr. McCord's office to the Chilean military attaché, the call to the Israeli embassy from Mr. McCord's home, and a similar call to the Chilean embassy. And I would respectfully invite the committee's attention to the fact that the first 2 of these calls occurred prior to my ever meeting Mr. McCord, before I ever represented the man. As a result thereof, I made an appropriate motion for disclosure of any government electronic surveillance in any way pertaining to Mr. McCord. Mr. Silbert's response was that he had no knowledge of any such surveillance. Again, at my client's insistence, I made a second similar motion at the bench during trial, explaining to Judge Sirica that I was doing so at my client's insistence, that such calls had in fact been made and had been electronically intercepted. The government again stated its total lack of knowledge of any such activity, and accordingly, no action was taken on my motion. My actions in this regard were consistent with and occasioned by my determination to defend my client to the best of my ability by utilizing any and all legal and proper means. In retrospect, I must conclude that my efforts were not, to say the least, appreciated. With regard to opportunities presented to Mr. McCord to tell all that he knew with regard to the Watergate operation, I state the following. On or about October 25, 1972, the government conveyed to local counsel, my local counsel, Mr. Bernard Shankman of Washington, and my associate, Mr. Johnson, an offer to accept from Mr. McCord a plea of guilty to one substantive count of the indictment, and in return for his testimony as a government witness, a recommendation of leniency would be made to the court. The government indicated, however, that it could not and would not recommend any type of suspended sentence which would allow Mr. McCord to remain at liberty. This offer was transmitted to Mr. McCord and was unequivocally rejected. In November of 1972, a second plea offer was received from the prosecutors. At this time, the offer was essentially similar to the first offer, except that Mr. McCord would have to plead to 3 counts of the indictment instead of 1. The explanation for this change of position was that the government's case had grown considerably stronger. This offer, which also involved Mr. McCord's testifying as a government witness, was related to and again rejected by Mr. McCord. I advised Mr. McCord after an in-camera session with Chief Judge Sirica during trial that there still existed an opportunity for him to appear before the grand jury, even at that stage of the trial, to make full disclosure. I have been informed that the committee has been provided with a transcript of that in-camera proceeding, and I therefore will not attempt to paraphrase the words of Chief Judge Sirica. Nevertheless, I relayed this information to Mr. McCord, and this third opportunity was again turned down. I take the liberty of bringing these three instances to the attention of this honorable committee since, in my opinion, Mr. McCord, in portions of his testimony before you, implied that I had pressured him to plead guilty and to remain silent. Senators, I state to you that this is not so, and respectfully refer you to the question asked of Mr. McCord by Senator Ervin on May 18, 1973, and I quote, question, "Now, did your lawyer urge you to enter a plea of guilty?" I am talking about Mr. Gerald Alch. Answer, I do not recall that. No, sir. That portion, at least, of Mr. McCord's testimony is accurate. With regard to the allegations of Mr. McCord to the effect that I suggested that the CIA be brought into the case in a defense posture, I state the following. As heretofore explained, I had decided to base Mr. McCord's defense on the theory of duress for two basic reasons. One, it was the only legally recognized defense that I felt was supportable. Two, more importantly, it appeared to be the factual truth based upon Mr. McCord's explanation of his own motive. In December of 1972, I attended one of several meetings of defense counsel, the purpose of which was to discuss various aspects of trial strategy. I proceeded to explain the defense that I was contemplating, duress. A discussion ensued wherein some of the other defense attorneys reasoned that this security motive, and by that they were referring to my contemplated defense of duress based upon what Mr. McCord had told me, would be applicable only to Mr. McCord in view of his position as Chief of Security for the committee to re-elect the President. In the general discussion that followed, the question arose as to whether or not the CIA could have been involved. It was pointed out by others, and I emphasize by others because at this point my defense of Mr. McCord had been formulated based upon what he had told me and with his concurrence. It was pointed out by others that all of the individuals apprehended in the Watergate complex had some prior connection with the CIA, and that one of the Cuban Americans had been in possession of what appeared to be CIA-forged documents. Before the meeting went on to other topics, it was agreed that each lawyer would ask his respective client whether or not he had any knowledge of any CIA involvement. When the meeting terminated, I telephoned Mr. McCord at his office by prearrangement and asked him to meet with me and my local counsel, Mr. Bernard Shankman, at the Monocle Restaurant for lunch. During lunch, which lasted for approximately 45 minutes, I asked Mr. McCord whether, to his knowledge, the CIA was in any way involved with the Watergate venture. He did not directly respond to this specific question, but did become quite upset at what he believed to be the antagonism of the White House against the CIA. He cited the dismissal of Mr. Helms as CIA director and the appointment of Mr. Schlesinger in his place as an attempted, quote, hatchet job, unquote, by the administration against the CIA. he did venture his observation that if any CIA officials were subpoenaed, that they would not and could not comply with said subpoena. Because of the brevity of the luncheon and because of the obvious need for more detailed pretrial meetings, I asked Mr. McCord to come to Boston in a few days, which he agreed to do. On or about December 26, 1972, Mr. McCord came to Boston and initiated our conversation by stating that the CIA was not involved and that he would have no part of any attempt to involve that agency. He asked that I relay this position to other defense counsel at our next meeting, which I agreed to do, and in fact did. I did not, after advising other defense counsel of Mr. McCord's denial of CIA involvement, engage with other counsel in any further conversation of any potential defense involving the CIA. At no time did I suggest to Mr. McCord that the so-called CIA defense be utilized, for the defense of duress had already been agreed upon, but I merely asked him whether or not there was a factual basis for this contention. Mr. McCord's allegation that I announced my ability to forge his CIA personnel records with the cooperation of the then acting CIA director, Mr. Schlesinger, is absurd and completely untrue. I have never had the privilege of meeting Mr. Schlesinger, nor the privilege of talking with the man. No such statement was ever made. I have no contact with the director of the CIA, let alone an agreement involving the forging of documents. My local counsel, Mr. Bernard Shankman, who was present at the Monaco restaurant, can corroborate that I did not say that. The remainder of my discussion with Mr. McCord in Boston was devoted to further analysis of the duress defense, and when the meeting ended, I told him I would keep in daily telephonic contact with him until our next meeting, which I tentatively scheduled for the first week of January, 1973. Between December 26, 72, and the first week of January 1973, I attempted to contact Mr. McCord on several occasions by telephone. But each time that I called, I was told that he was not in, and my requests for a return call were not answered. This puzzled me, for up to that point, it was Mr. McCord's habit to return my calls immediately upon him receiving any message from me so to do. On or about January 2, 1973, I received a call from local counsel Bernard Shankman, who advised me that Mr. McCord had or was about to deliver a letter to Chief Judge Sirica dismissing me as his counsel. This was a shock to me, for at our last meeting in my office on December 26, 1972, we parted on a most cordial note and in complete agreement upon the theory of his defense. I asked Mr. Shankman to advise Mr. McCord that I would fly into Washington on January 3, 1973, to speak with him on this matter. I did meet with Mr. McCord after I had learned that a letter of dismissal had in fact been given to Chief Judge Sirica, and that Chief Judge Sirica's position was that I was still counsel of record and that this development would not afford a basis for a continuance. When I met Mr. McCord, he picked me up at the airport in Washington. I expressed to him my astonishment at his action and asked him why he had acted in such a way. Mr. Shankman had told me that one reason cited to him by Mr. McCord was the question regarding the CIA defense. I brought this up to Mr. McCord and said to him in substance, I thought that issue was you laid to rest by mutual consent when you denied any factual involvement on the part of the CIA at our last meeting in Boston. He agreed that it was, but said that was not the reason for his letter. He claimed that I had not been maintaining sufficient contact with him and that he was unsure of my being adequately prepared for trial. I told him that in my opinion this was not so, that he had the right to any lawyer of his choice, and that if he wished to dismiss me, that was his prerogative. I pointed out what I had viewed as a most satisfactory attorney-client relationship based upon mutual trust and confidence, and suggested that if he had any grievance with me, he should advise me of the same face to face, rather than refusing to answer my phone calls and unilaterally, without my knowledge, delivering to the judge a letter of dismissal. When I said this, he became defensive, apologized for what he described as a, quote, lack of communication and misunderstanding, unquote, and expressed his desire to maintain me as counsel. Again, he voiced his confidence in me and extended his hand in affirmation of that confidence. On January 8, 1973, the first day of trial, I learned that Mr. William O. Bittman's client, Mr. Hunt, had offered to plead to any and all counts of the indictment immediately prior to trial, but that Chief Judge Sirica had said that he would not entertain any change of plea until after jury selection and opening statements. This appeared to me to be highly prejudicial to my client, for it would tend to give the jury the impression that after the government's opening statement, one of the defendants had thrown in the towel, so to speak, overwhelmed with the weight of the evidence against him. I felt that this could and should have been avoided by a change of plea being resolved prior to the commencement of trial, since this had been the request of Defendant Hunt. I had told Mr. McCord that our routine, once trial began, would be for him to spend some time each day immediately after court with Mr. Shankman and myself to review what had gone on that day and to discuss what was to happen the following day. I wanted to discuss with Mr. Bittman the details of his client's proposed change of plea in order to ascertain whether or not there would be a basis for a mistrial. It was agreed that we would meet at his office immediately after court was concluded for that day. Mr. Shankman, Mr. McCord, and I hailed a cab, and at the last minute, co-defendant Barker asked if he could ride in the cab with us. Where at that time Mr. Barker was going, or why he was going to Mr. Bittman's office, as I eventually ascertained, I do not know. There was no significant conversation with Mr. Barker in the cab. Mr. McCord has alleged that I told him that the purpose of going to Mr. Bittman's office was that Mr. Bittman wanted to talk with him, Mr. McCord, about, quote, whose word he would trust regarding a White House offer of executive clemency, unquote, and that Mr. Bittman wanted to talk to Mr. Barker as well. This is not true. I merely said to Mr. McCord that prior to the scheduled daily post-court meeting between he, Mr. Shankman, and myself, that we would stop at Mr. Bittman's office, for I wanted to discuss with him the ramifications and the details of Mr. Hunt's proposed change of plea. When we arrived at Mr. Bittman's office, Mr. McCord has alleged that I sensed his anger at Mr. Barker's presence and therefore delayed going up to Mr. Bittman's office for approximately 30 minutes. The simple truth is that I suggested, when we got out of the cab, that we three have a cocktail. And Mr. McCord, Mr. Shankman, and I went to a restaurant directly across the street from Mr. Bittman's office for just that purpose. When we arrived at Mr. Bittman's office, I went with Mr. McCord and Mr. Shankman to the firm's library and went back to Mr. Bittman's office to see if he was there. I had a discussion with him, Mr. Bittman, in which he confirmed the judge's refusal to entertain any change of plea by Mr. Hunt until after opening statement. Excuse me. At this point, I recall mentioning to Mr. Bittman that I felt my client was becoming a bit paranoid, that he felt he was being made the patsy or the fall guy. I mentioned it at that time since, in my mind, that allegation made to me by Mr. McCord seemed inconsistent with Mr. Hunt's desire to plead guilty. After I mentioned Mr. McCord's apprehension, my recollection is that Mr. Bittman said in words or substance, "Tell Mr. McCord he'll receive a call from a friend of his." Mr. Bittman did not mention the White House as alleged by Mr. McCord. The identity of this friend was not made known to me, nor did I make inquiry in this matter. I considered the possibility, without actually knowing, if you'll excuse me, gentlemen, I seem to, I have it, I beg your pardon, that the purpose of this call was to allay Mr. McCord's fears that his co-defendants were turning against him, and that the caller could very well be Mr. Bittman's client, Mr. Hunt. This was surmise on my part. I considered this possibility in view of the context of the conversation immediately preceding Mr. Bittman's remark, that is, my statement, in accordance with Mr. McCord's request, of his apprehension with regard to his co-defendants. I subsequently told Mr. McCord just what Mr. Bittman had told me, that he would receive a call from a friend. I did not mention the words "the White House" because Mr. Bittman did not mention those words to me. Mr. McCord nodded, said okay, and had no further response to my statement. Sometime later, as the trial was in progress, Mr. McCord told me that he had been in contact with a man by the name of Caldwell. That's how I remember it as he told it to me. He specifically stated that he did not wish to tell me who this man was or the subject matter of his conversation with him. In response, I told Mr. McCord that that was his prerogative. In this regard, I respectfully invite the attention of this honorable committee to Mr. McCord's letter to Chief Judge Sirica of March 19, 1973, of which I had no prior knowledge. I respectfully refer to the next to last paragraph of page 2 of this letter, and I have provided copies of this letter to this honorable committee, where, after alleging complaints about various topics, including but not limited to an allegation that there was political pressure applied to the defendants to plead guilty and remain silent, Mr. McCord, in the second to last paragraph on page 2, stated, and this letter was written without my knowledge, and I quote, "I have not discussed the above with my attorneys as a matter of protection for them." Mr. McCord has alleged that the subject of executive clemency was discussed on this day, January 8, 1973. This is not true. In late 1972, during one of the pretrial meetings of all defense lawyers in Washington, I had an occasion to say to Mr. Bittman, "Bill, what do you think our clients will receive as a sentence should they be convicted?" Mr. Bittman responded in substance, as if he were theorizing, "You never can tell. Christmas time rolls around, and there can be executive clemency." I scoffed at this notion and told Mr. Bittman that, in my opinion, the President would not touch this case with a 10-foot pole, let alone exercise executive clemency. This subject had not been on any agenda, but arose in what I characterize as lawyers' talk. Subsequently, but not on that same day, I mentioned this to Mr. McCord in a most skeptical manner and said to him, "Jim, it can be Christmas, Easter, and Thanksgiving all rolled into one. But in my opinion, the President will not touch this case with a 10-foot pole, so don't rely on any prospect of executive clemency." Mr. McCord laughed and agreed with me. That was the only occasion that the words executive clemency were ever mentioned by me to my client. I have neither met John Dean nor spoken to him in my life. I have neither met John Caulfield nor spoken to him in my life. During the trial, I presented to Chief Judge Sirica my contemplated defense theory of duress, supported by a memorandum of law. Several days later, after receiving a written response from the government, the court ruled as a matter of law that this defense did not apply to this case, thereby precluding me from presenting evidence in support thereof and from relying upon it in closing argument. After opening statement, Mr. Hunt and the 4 other Cuban-American defendants pleaded guilty, at which time I filed a motion for mistrial, which was denied. When this happened, I explained to Mr. McCord the only possible remaining defense was the general defense of lack of criminal intent, but advised him that, in my opinion, it had little or no legal merit, for it was asking the jury to believe that he did not know he was breaking the law when he broke into the Watergate complex, and this, to say the least, was not very saleable. Mr. McCord indicated his understanding of our position, told me that he was nevertheless most pleased with my exerting my best efforts with regard to the proposed theory of duress, and asked whether or not the judge's ruling could be a point of appeal in the event of conviction. I told him that it could and would be, that the record had been made in that regard, and he indicated his complete satisfaction with the then existing situation. As the trial approached the completion of the government's case, I conferred with Mr. McCord at one of our daily post-trial meetings and told him that a decision would have to be made regarding whether or not he would take the stand. I explained to him that if he elected to testify, it would be his obligation to answer any and all relevant questions. It was at this time that Mr. McCord told me that he had evidence to the effect that the Watergate operation had been approved by John Mitchell. I asked him the nature of the evidence, and he told me he had been so advised by Mr. Liddy. I asked him if he had any other corroborative evidence, and he told me he did not. I told him that although this was technically hearsay, it would be admissible as a declaration by one co-conspirator to another, and told him to understand beyond any doubt that should he take the stand, that question would, in my opinion, be asked and an answer required. I told him that if he elected to take the stand, full disclosure would be necessary, that I was with him all the way, but that this crucial decision of whether or not to testify could only be his.
Gerald Alch, James McCord's original lawyer, says McCord repeatedly praised the defense job he was doing before turning on him and testifying that Alch suggested McCord somehow could link the CIA with his trial. During this first part of his testimony, Alch described what he said was a good relationship with McCord. When testimony resumes, he continues to recount the causes of their ultimate separation, and that'll come in a few minutes. While we pause during our uninterrupted primetime coverage, we'd just like to thank all of you who've taken the trouble to write us and express your approval of this kind of coverage. If any of you still care to, you could write us at NPACT, Box 300, Washington, D.C. NPACT's continuing coverage of the Watergate hearings resumes after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
Gerald Alch now resumes his testimony, explaining how the lawyer-client relationship between him and James McCord deteriorated.
The grounds of appeal would be in the event of conviction. I reviewed them with him. mentioning such things as the court's denial of my motions for mistrial, based upon the timing of the change of plea by his 5 co-defendants, as well as the ruling by Chief Judge Sirica precluding the defense of duress. He told me he had decided not to testify. I asked him if he had any reservations regarding that decision, and he said he did not. As the jury announced its verdict, I immediately asked the Chief Judge to be heard on the matter of bail, which request was denied. The court advised that the motion be put in writing so as to allow the government to respond. I immediately set to work upon this, urged the prosecution to respond as quickly as possible, and several days later a hearing was held, at which time bail was set in the amount of $100,000. What I am now about to relate is not for the purpose of self-commendation, but is stated to show and emphasize the relationship that existed between Mr. McCord and I from the beginning to the end of trial. There was not a day of trial that passed without Mr. McCord shaking my hand at the end of each day and telling me what a superlative job I had done. He used adjectives such as terrific, outstanding, and expressed his total and unequivocal satisfaction and appreciation for my efforts. I remember the day of final argument when present in the courtroom were Mr. McCord's wife, his son, his daughter, and his parents. After my final argument, they all came up to me and profusely thanked me for the words I had uttered on Mr. McCord's behalf. They said they were proud of my description of Mr. McCord and that they were thrilled to sit there and hear it. Mrs. McCord had previously told me of her anxiety over what the effects of the trial might have on her son, who was a student at the Air Force Academy. On the day of the final argument, she asked if I could obtain for her a copy of the argument so that she could give it to her son. When the jury announced its verdict of guilty, Mr. McCord turned to me. He extended his hand and said, "There is no one that could have done a better job than you did. You are a terrific lawyer, and I shall always be grateful to you." It was, to me, an emotional moment. My local counsel, Mr. Shankman, can bear witness to this. To further demonstrate the status of my relationship with my client, I have provided this honorable committee with a copy of my letter to Mr. McCord dated February 6, 1973, while he was incarcerated at the District of Columbia Jail. I specifically refer the attention of this honorable committee to the 3rd paragraph of that letter, which reads as follows. This is my letter to Mr. McCord. I again reiterate to you that I shall continue to do everything possible on your behalf and shall stay with you in all that may lie ahead. Having a client convicted can never be a source of gratification to an attorney. I will, however, always remember your vote of confidence in me before, during, and after trial. I immediately commenced my efforts to effectuate Mr. McCord's release on bail. The record will reflect that a petition to reduce the bail set by Chief Judge Sirica was filed in the Court of Appeals for the District of Columbia at the earliest possible time. I made several visits to Mr. McCord in the District of Columbia Jail. I remember his expressing dissatisfaction at being placed in a maximum security area. I immediately spoke to the prison superintendent and asked if anything could be done. No commitment was made, but I was told that my request would be given every consideration. I remember that approximately a week after the trial ended, my wife and I went on a 4-day vacation to Jamaica, and even then, I made at least one, if not two, denial of my motions for mistrial, based upon the timing of the change of plea by his 5 co-defendants, as well as the ruling by Chief Judge Sirica precluding the defense of duress. He told me he had decided not to testify. I asked him if he had any reservations regarding that decision, and he said he did not. As the jury announced its verdict, I immediately asked the Chief Judge to be heard on the matter of bail, which request was denied. The court advised that the motion be put in writing so as to allow the government to respond. I immediately set to work upon this, urged the prosecution to respond as quickly as possible, and several days later a hearing was held, at which time bail was set in the amount of $100,000. What I am now about to relate is not for the purpose of self-commendation, but is stated to show and emphasize the relationship that existed between Mr. McCord and I from the beginning to the end of trial. There was not a day of trial that passed without Mr. McCord shaking my hand at the end of each day and telling me what a superlative job I had done. He used adjectives such as terrific, outstanding, and expressed his total and unequivocal satisfaction and appreciation for my efforts. I remember the day of final argument, when present in the courtroom were Mr. McCord's wife, his son, his daughter, and his parents. After my final argument, they all came up to me and profusely thanked me for the words I had uttered on Mr. McCord's behalf. They said they were proud of my description of Mr. McCord and that they were thrilled to sit there and hear it. Mrs. McCord had previously told me of her anxiety over what the effects of the trial might have on her son, who was a student at the Air Force Academy. On the day of the final argument, she asked if I could obtain for her a copy of the argument so that she could give it to her son. When the jury announced its verdict of guilty, Mr. McCord turned to me. He extended his hand and said, "There is no one that could have done a better job than you did. You are a terrific lawyer, and I shall always be grateful to you." It was, to me, an emotional moment. My local counsel, Mr. Shankman, can bear witness to this. To further demonstrate the status of my relationship with my client, I have provided this honorable committee with a copy of my letter to Mr. McCord dated February 6, 1973, while he was incarcerated at the District of Columbia Jail. I specifically refer the attention of this honorable committee to the third paragraph of that letter, which reads as follows. This is my letter to Mr. McCord. I again reiterate to you that I shall continue to do everything possible on your behalf and shall stay with you in all that may lie ahead. Having a client convicted can never be a source of gratification to an attorney. I will, however, always remember your vote of confidence in me before, during, and after trial. I immediately commenced my efforts to effectuate Mr. McCord's release on bail. The record will reflect that a petition to reduce the bail set by Chief Judge Sirica was filed in the Court of Appeals for the District of Columbia at the earliest possible time. I made several visits to Mr. McCord in the District of Columbia Jail. I remember his expressing dissatisfaction at being placed in a maximum security area. I immediately spoke to the prison superintendent and asked if anything could be done. No commitment was made, but I was told that my request would be given every consideration. I remember that approximately a week after the trial ended, my wife and I went on a 4-day vacation to Jamaica, and even then, I made at least one, if not two, daily phone calls to Mrs. McCord on the question of bail. My concern was to effectuate the release of my client as soon as possible. I recall my first visit to Mr. McCord at the jail. When he first saw me, he was approximately 20 feet away. He broke out into a wide smile, extended his hand, and accelerated his pace. He told me how glad he was to see me, so that he might again express his gratitude for my efforts in his behalf. I told him of my immediate appellate action regarding bail and of my daily telephonic contact with his wife, and he thanked me profusely. I remember him telling me how fortunate he felt to have me working so hard as his attorney, and he again re-emphasized his belief that my job for him was beyond reproach. He told me that his wife was contacting friends with regard to bail, but he specifically asked that I call a man by the name of Bernard Finsterwald, whom he said might be very helpful in raising bail. This was the first time I had heard the name. I did not ask who this man was or what his relationship to Mr. McCord was, merely made note of his name and telephone number and called him from the payphone at the jail immediately after leaving Mr. McCord. I introduced myself as Mr. McCord's attorney and told Mr. Finsterwald the purpose of my call. He told me that he thought he could arrange to meet the bail requirements within a matter of days, that he had friends with whom he was in contact, that these friends stated that things looked good, and that I should stay in daily contact with him. I immediately related this hopeful news to Mrs. McCord, and she was understandably overjoyed at the prospect of her husband's imminent release. Daily phone calls were made to Mr. Finsterwald. I was not always able to reach him directly, but when I did, he would tell me that his friends were still working on it and to keep in daily contact. Several days passed. The word from Mr. Finsterwald was still inconclusive. That is, he was still waiting word from other people. Then, during one of my telephone calls, he told me that these other contacts had fallen through, but that he was ready, willing, and able to personally borrow the full amount of $100,000, and that he could do so by just going down to the bank and signing the note. He told me that his motive for so acting was that he was outraged at the high bond set by Chief Judge Sirica and felt this to be a gross injustice which he was taking upon himself to rectify. This was, I believe, in February of 1973. I told him I would call him the following day. When I did so, he told me that he had been refused by the bank, but that he was looking to another source for the funds. He did not specify, nor did I ask the identity of the source. He did tell me, however, to ascertain from Mrs. McCord how much she could raise through friends and relatives so that he could attempt to come up with the balance. I again visited Mr. McCord and advised him of the progress. He had been in jail for some 2 weeks now, and I sensed his anxiety was increasing. He told me that when I spoke to Mr. Finsterwald again, I was to be sure to relate to him Mr. McCord's gratitude. I left Mr. McCord, went to the phone booth in the jail, called Mr. Finsterwald, and related Mr. McCord's thanks. Mr. Finsterwald's reply was, and I quote, "I don't see how he can send his thanks to me because I've never even met the man," unquote. This seemed unusual to me, to say the least, that a man would be doing what Mr. Finsterwald said he was trying to do for someone he had never met. But I was not about to look a gift horse in the mouth. My sole concern was for my client, and my immediate objective was to effectuate his release on bail. Mrs. McCord subsequently advised that she was able to raise $60,000. I related this to Mr. Finsterwald, who said he would be able to produce the remaining $40,000. This was shortly thereafter accomplished, and Mr. McCord was out on bail, awaiting sentencing. In the following days, I was involved with legal commitments which took me out of Boston, but kept in telephonic touch with Mr. McCord. Our relationship remained most cordial. When the date of the sentencing arrived, I was engaged in trial in federal court in Chicago, Illinois, before the Honorable Judge Hoffman. I asked for and received permission to adjourn the trial for the day of sentencing so that I might be present with Mr. McCord in court. This was the day when Chief Judge Sirica read in open court Mr. McCord's letter of March 19, 1973, of which I had no prior knowledge. When Chief Judge Sirica called a 20-minute recess immediately following his reading of the letter, I sat with Mr. McCord at the counsel table and asked him why he had not informed me of his intentions. He apologized for so doing and again repeated that he had not advised me of his allegations in the letter as a matter of my own protection. I asked him what he wanted me to do. He told me he wished to speak privately, with me being present, to Chief Judge Sirica regarding the allegations of his letter and asked that I advise the court of this request. During this conversation, a man approached Mr. McCord and said, in what I can best describe as a whispered or hushed manner, quote, "If you need an office, you can use mine right after court," unquote. Mr. McCord nodded, and I asked Mr. McCord who this man was. Mr. McCord identified the individual and introduced him to me as Mr. Bernard Finstewald. This was the first time that I had met the man with whom I had had so much telephone contact pertaining to bail. Mr. McCord said to Mr. Finstewald in my presence, and I quote, "The one thing I feel sorry about is keeping Jerry in the dark and pulling this on him," unquote. Mr. Finstewald replied, quote, "Sorry hell, let it all hang out," unquote. When court reconvened, I relayed to the Chief Judge Mr. McCord's request, which at that time was granted, and an in-camera meeting was tentatively set up for the following week. I naturally was embarrassed at not having been advised by my client as to so crucial and dramatic a move. I'm talking about his letter to Chief Judge Sirica. But reasoned to myself that after all I had been away, engaged in trial. Mr. McCord's apology seemed most sincere, and I therefore chose not to make an issue out of this failure of communication. This, I recall, was on a Friday. It was on the same day that Mr. Samuel Dash of this committee came up to me, introduced himself, and asked if he could converse with Mr. Cord, or said that he was interested in doing so. I told him that it was Mr. McCord's immediate request to speak with Judge Sirica, and that I would be happy to relay to Mr. McCord Mr. Dash's request. I then resumed my Chicago trial, and in the newspapers read that Mr. McCord had begun to confer with Senate investigators. I found out about it that way, reading it in the newspapers. Subsequently, Mr. McCord called me and said that since I was away on trial, and that since things were breaking so quickly, didn't I think it was a good idea for him to retain local Washington counsel? I said, yes, I thought it was a good idea. He asked me if I had any objection to Mr. Finstewald. I said I had none, and Mr. McCord advised me this would be done. My next contact with Mr. McCord was when he and I and Mr. Finstewald met the night before our last court appearance before Chief Judge Sirica, at which time in court that day the sentencing was continued until June 15, 1973. I remember Mr. McCord was extremely upset over what he believed to be unfair newspaper coverage of his disclosures. He kept smashing his fist on my suitcase. At this point, Mr. Finstewald said to Mr. McCord, quote, "The reporters have been asking me whether or not you or I had ever had any past relationship. I told them that we had." This is Mr. Finstewald speaking. At this point, Mr. McCord looked up with what, to me, was a surprised expression. Mr. Finsterwall said, "Well, after all, you have in the past submitted to me checks which were donations to the committee for the investigation of the assassination of the president." Mr. McCord smiled and said, "Oh, yeah, that's right." Prior to the court appearance of the following morning, at a meeting at Mr. Finsterwald's office, it was agreed that since my immediate trial schedule called for me to remain in Chicago for an anticipated period of 6 to 8 weeks, that Mr. Finsterwald would continue to represent Mr. McCord in my absence, both in the criminal matter and in all hearings before the grand jury and this honorable committee, but that upon the completion of my trial duties, I would again assume my role as counsel in these matters. That morning in court, I asked for and received a continuance of sentencing to June 15 of this year. I advised the court of Mr. McCord's desire to cooperate fully with both the grand jury and Senate committee, and further advised of Mr. McCord's preference to first testifying before the Senate committee. When court was over, I said to both Mr. McCord and Mr. Finsterwald that I would be happy to continue my representation of Mr. McCord, but asked that in the future, as long as I continued in that capacity, that I at least be given the courtesy of being kept abreast of Mr. McCord's activities, so that I would not again be embarrassed. Both Mr. McCord and Mr. Finsterwald agreed that this was proper. Mr. McCord again apologized to me, and Mr. Finsterwald told me that he would call me wherever I was every day, even if he had nothing to tell me. The meeting ended with all of us shaking hands, and I flew out of town. I have not seen either Mr. McCord or Mr. Finsterwald since that time. Subsequently, while I was still on trial in Chicago, I did receive several phone calls from Mr. Finsterwald, although not daily as he had promised. And I might add, although not reflected in the memorandum for the sake of accuracy, some of these calls I received when I was staying at the Holiday Inn on Lakeshore Drive in Chicago, and other of these calls I received when I was staying at the Chicago Sheraton Hotel in Chicago. In one of these conversations, he said to me, quote, this is Mr. Finsterwald talking, "What do you think of all that's going on?" referring to the disclosures being made by Mr. McCord to this honorable committee. I replied, "Whatever is right for Jim McCord is all right with me." Mr. Finsterwald replied, and I quote, "We're going after the President of the United States." I replied that I was not interested in any vendettas against the President, but only in the best interest of my client, to which Mr. Finsterwald replied, "Well, you'll see, that's who we're going after, the President," unquote. I might add at this point, Senators, although it is not contained in the memorandum, an investigator from my office was in my hotel room when this conversation took place. And I recall putting the phone down and turning to my investigator, whose name is John McNally, and said to him, "You'll never believe what I just heard on this telephone." And I told him. And his response to me was, "Too bad you didn't have that recorded." During another telephone conversation with Mr. Finsterwald, he stated that he was most displeased with the reaction of the Republican members of this honorable committee to Mr. McCord's submitted memoranda, and further stated, "I'll submit memoranda, but I don't want the Republicans to see them." During a third telephone conversation, he advised of Mr. McCord's intention to hold a national press conference. I replied that in my opinion this would demean Mr. McCord's position and that he should stay within the framework of both the grand jury and the Select Senate Committee. I further stated that to hold such a press conference could conceivably antagonize Chief Judge Sirica. Mr. Finsterwald replied that he would attempt to obtain approval of such a press conference from Senator Ervin, and that if such approval was obtained, this would be presented as a mitigating factor in the event of Chief Judge Sirica's displeasure. Subsequently, my contact with Mr. McCord and Mr. Finsterwald diminished, and I immediately, after the completion of my Chicago federal case, commenced a 5-week murder trial in Cook County, Chicago. On May 8, 1973, my secretary gave me a message reflecting a call from the Los Angeles Times from a reporter whose name I recall to be of Jackson, in regard to a 4-page memorandum of Mr. McCord involving the CIA that was about to be published the following morning. I called Mr. McCord that night and was told by his wife that he was not in, and I left a message for him to call me. He never did. The following day, the New York Times published the memorandum by Mr. McCord alleging that I had stated that I could obtain forged CIA documents with the cooperation of the director of the CIA. I again called Mr. McCord. My client and his wife told me that he was at a meeting and that she would once again relay my message to him, but he never called. At approximately 5:30 p.m. on May 8, 1973, I contacted Mr. Finsterwald by telephone and asked him to explain these false allegations made by Mr. McCord. Mr. Finsterwald stated, quote, "I can only hazard the guess that it is the result of Mr. McCord's faulty recollection." He added, "I can tell you one thing, it's a terrible cliche, but I think you will agree with it, that there is no zealot like a convert." I have had no further contact from Mr. McCord. Mr. McCord has accused me of exerting pressure upon him, but I respectfully request this honorable committee to take note of the following facts. 1, Mr. McCord did not plead guilty. 2, he admitted under oath in response to a question put to him by Senator Ervin that I never urged him to enter a plea of guilty. 3, in his letter of March 19, 1973 to Chief Judge Sirica, in referring to his allegations of improprieties, including but not limited to political pressure, he stated, and I quote, "I have not discussed the above with my attorneys as a matter of protection for them," unquote. 4, Mr. McCord proceeded to trial with a defense based upon what he told me to be the truth. I have done nothing wrong and therefore am not afraid, but I am upset as a practicing criminal trial lawyer. I must confess that I am the type of criminal defense attorney who, rightly or wrongly, gets emotionally involved with his client's cause. I remain fully cognizant of the fact that a man's liberty is at stake, rather than a determination of dollars and cents. I ask my client to take me into his confidence, and I reciprocate. I keep him constantly advised of my thoughts and my theories. To me, this attitude of complete disclosure is based upon my interpretation of the duty that I owe to the man that I am defending. how can a lawyer effectively represent his client when faced with the possibility that the man for whom he is working night and day is constantly making a record of privileged conversations with the intent of subsequently violating this privilege by making false accusations and by selectively extracting statements out of context and twisting them into untruths? Can a defense attorney function properly under such circumstances? I have always made a practice not to comment on matters of which I have no knowledge. Mr. McCord has made accusations directed towards many men. I am in no position to judge his credibility in that regard. I do, however, have first-hand knowledge of his relationship with me, and in regard to his accusations against me, he is not telling the truth. As I watched Mr. McCord on national television on May 18, 1973, and listened to him falsely accuse me of professional misconduct, which accusations are false in every respect, I immediately and vividly recalled his praise for me throughout the trial, his confidence expressed to me at the time of the guilty verdict, and his further expression of gratitude during the period of his incarceration. And I asked myself, what kind of a man is this? I stand ready to answer all questions.
We have to vote in just a few minutes on the nomination of Mr. Richardson to be Attorney General, and this is a long statement, and I think the committee, as I understand it, thinks it'd be better to adjourn now and come back in the morning, 10 o'clock, before we begin the questions. So we'll stand in recess till 10 o'clock in the morning.
So the full session of the Senate called to confirm Elliot Richardson as Attorney General cut short today's hearings. Like the others, today's session gave us a new set of surprises and new uncertainty about who will testify next. At the center of that controversy is James McCord, who today heard his former attorney charge him with making false accusations. And after the hearings, he held a hectic news conference outside the hearing room.
I've asked for an opportunity to appear before the committee again in rebuttal, and I'll go into it as fully as I'm able at that time.
Could you say it's wrong? Could you tell us this, Mr. McCord? What's your feelings now about Mr. Alch, your personal feelings? He said that you were close friends.
Well, did you express confidence in him many times during and shortly after the trial, Mr. McCord?
Oh, yes, before January.
Is it fair to say that confidence no longer exists?
I think it's evident.
After the final gavel, INPAC correspondent Peter Kay did some checking on how today's developments will affect tomorrow's schedule. And I asked Peter what's going to happen next in that hearing room.
Well, Jim, I expect we'll begin just where this very confusing session left off today, with Gerald Alch, James McCord's deposed attorney, on the witness stand, and committee members are sure to ask him about his testimony, particularly the part in which he alleges that his successor, Bernard Finsterwald, was part of a vendetta out to get the president. Whether McCord or Finsterwald will ever get back to the witness stand is a matter for conjecture right now. Normally, under committee rules, they will not. They will be asked to make a written rebuttal to sort of keep this lawyer against lawyer thing from escalating on and on forever. Following Alch on the witness stand are Alfred Baldwin III, the former FBI agent who was bugging, or who was recording the bugging at Watergate, Sally Harmony, the secretary to G. Gordon Liddy, another Watergate conspirator, and Bernard Barker, still another Watergate conspirator. This is probably going to end this particular round of hearings until they resume for another month.
Watching the hearings with us for the past 4 days have been our two resident experts, Bill Greenhall of the Georgetown University Law School and Alan Barth, a Washington author and journalist. And Barth has been watching hearings for years, and I asked him to play the role of drama critic for today's action.
I don't see how the drama could have been any higher. It had all the essence of drama, suspense and tension, and we'll have to wait for the resolution. I remember committee inquiries in the 1950s when the purpose of the committee was simply to pillory a witness. I remember most hideously of all the 12 days during which Owen Lattimore was put before the McCarran Committee of the Senate and baited as though he were a chained bear. It was a horrible performance. There was none of that here today. There was the drama which grew out of conflict and contradiction between individuals, presenting an opportunity to the committee and to the public to make their own judgments.
Tell us again quickly who Owen Lattimore was.
Owen Lattimore was accused by Joe McCarthy, Senator Joe McCarthy, of being the arch spy for the Soviet Union in the United States. And he was, for 12 successive days, kept on the witness stand and grilled successively by different members of the committee, all of them hostile. His attorney at that time was Abe Fortas, and he was given really no opportunity whatever to assist his client or do anything for his defense.
Of course, the dramatic conflict in this case, however, revolves around, you had to have heard McCord to really understand the dramatic impact of what Alch said today, right?
Yes, well, I suppose that as the committee proceeds with its inquiry, we're going to get a series of contradictions, of conflict, human conflict on this stage of the committee investigation forum, and that does seem to me to be the very essence of drama.
Bill Greenhall, what tools does the committee have available to resolve these obvious discrepancies in testimony?
Well, if the committee feels that one of the witnesses is not telling the truth, inasmuch as they have been sworn to tell the truth, they may refer the matter to the criminal division of the United States Department of Justice, where it'll be assigned to a trial attorney in that division as to whether or not prosecution should be instituted. And that matter then would be referred to the United States Attorney's Office for the District of Columbia for prosecution.
It seems possible or probable at this point that the committee will not allow McCord to come on tomorrow and rebut Alch, and also not allow Finsterwald. Is my interpretation of the initial committee guidelines incorrect, or did they not say that if anybody's name is mentioned that they had an opportunity to come and rebut it or to answer it? And wouldn't this apply to Finsterwald? He hasn't testified.
I would imagine Mr. Finsterwald would be very uncomfortable, because if anybody was put right square in the limelight with regard to an allegation made about getting the President of the United States, that he should be given that opportunity that Mr. Alch was given after McCord testified, saying that he made all these improper allegations with regard to his representation. So I don't know what fairness is floating through the committee right now, but I think they owe some responsibility to Mr. Finsterwald in this regard.
Yeah. Gentlemen, thank you very much.
Mr. Barth will be back to us with us tomorrow, accompanied by a colleague of Mr. Greenhall's from the Georgetown Law Center. We're still curious about your reaction to this kind of unedited gavel-to-gavel coverage in prime time. Now, more than 20,000 of you have been kind enough to write us, and most of you express your approval of this kind of coverage. If anybody else still wanted to do that, you could write to us at NPACT, Box 300, Washington, D.C. 20044. Your comments on our coverage will help decide whether such programs will be presented in the future. In conclusion, perhaps it would help you have a little progress report on these extraordinary hearings. The committee scheduled 8 days of hearings, 5 in May and 3 in June, for what's being called the first round. 22 witnesses, including some of the once most powerful men in the Nixon administration, were scheduled to testify. Well, today we're halfway through those 8 days, and so far only 4 of the 22 scheduled witnesses have appeared. 5 others who have testified have been forced in by the pressure of unfolding facts. That means it's very unlikely that the committee will complete its first round on schedule, especially considering the heavyweight witnesses to come. They will either have to schedule more days after the Memorial Day recess or stretch further on into June. At the same time, despite its impeccable presentation and efficient management, the committee's not been able to keep the story very tidy. Increasingly, it becomes like one of those old-fashioned novels where the plot gets interrupted every time a new character turns up and wants to tell his life story. To date, adding up the main plots and subplots, Watergate might have even a novelist like Tolstoy confused. It now appears to involve not only the White House, the Justice Department, the CIA, the FBI, the SEC, the Committee to Re-elect the President, an employee of the Treasury Department, but now a mess of federal prosecutors and defense attorneys all struggling to save their own reputations. And if that isn't confusion enough, we'll probably be able to improve on it tomorrow. I'm Robert McNeil for Jim Lehrer and Peter Kay. Good night for NPACT.
From Washington, you've been watching gavel-to-gavel videotape coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. This coverage is made possible by grants for special events coverage from the Corporation for Public Broadcasting and the Ford Foundation, and has been a production of NPACT, a division of the Greater Washington Educational Telecommunications Association.